Yes.
Two similar kind of writ petition, where the petitioners had sought for approval in a DA getting school. Now, the school has placed the papers to the DI, Kolkata. The DI has sought for further papers, which the school is not for last 7 months, is not sub. Now, there is every chance that we are not getting the approval and the enhanced.
That it cannot wait till tomorrow.
Only one line order by London is appearing for the school.
Wait, let his lordship come.
But it will take only 1 minute of my lord's
Doesn't
time.
matter. Question is, the order will be wholly without jurisdiction. Because only the urgent matters are in my determination. And show me that urgency that it cannot wait till tomorrow. Then only.
May
urgent.
I seek some mercy from your lordship? If your lordship kindly.
No. This will amount to encroachment of jurisdiction.
Encroachment?
Of course. A matter, interim order is expiring. A matter, demolition, yes. A matter, threat of removal from service, the notice says tomorrow, yes.
But there is no such notice, but if your lordship...
It cannot be.
Very well. I will not disturb you. Very well.
Thank you, sir.
Lordship, may I be permitted to mention from list and determination of His Lordship Honorable Justice Bhattacharya, my lord?
First, you be satisfied that the matter cannot wait till tomorrow.
Yes, my lord. Because
it cannot wait till tomorrow.
Lordship,
yes, show me.
Lordship, this matter is pending since 2024, my lord. But very recently, the petitioner went to a cervical surgery, my lord. After that, his financial condition is so bad, my lord. He is not receiving his pension, that he is even having hardship to arrange his 2 square meals, my lord.
All right.
I have attached the 2 prescriptions as well, my lord.
Wait till his lordship come back.
Permitted to mention an urgent matter, lordship, of the determination of Honorable Justice Shobhata Bhattacharya. Lordship,
take the microphone and tell me that it cannot wait till tomorrow.
Lordship, Lordship, may I? Lordship, the petitioner in this matter, Lordship, is a divorcee daughter, and the only Lordship, in this matter, Lordship, the petitioner is a divorced daughter. And
divorced daughter, not receiving family pension.
Yes, Lordship, pertaining to area
pension. Wait.
Lordship, since 2014, Lordship, it's pertaining to.
Since 2014.
14,
so wait for more 14 days.
Lordship.
Yes.
Madam, may I be permitted to inclusion one motion, new motion?
My determination.
My lord.
Service.
My lord.
What is the urgency?
Urgency is this, my lord. Petitioner before his lordship is a contractual employee. Commensurate to the notification issued by the finance department, the salary.
All right, September monthly list.
September. But kindly.
Motion service, September monthly list.
August.
Next.
Lordship, may I kindly be permitted a
motion service, September monthly list.
Lordship, mentioning a matter for release, matter has been wrongly filed before this.
Wrongly filed before this court.
Lordship, the matter relates to police in action has.
Matter
relates to police in action and has been wrongly filed.
Police in action.
Yes, Lordship.
And has been filed in service matter. All right. To be mentioned tomorrow. Give the slip.
Well, I mentioned on matter, group 2.
কালকে টু বি মেনশনড দিয়ে দেবেন ব্র্যাকেটে লিখে দিন রিলিজ
mention one matter group 2 motion, my lord. But petitioner is retired.
It cannot wait till tomorrow. If it is so, then only mention, or else no.
Petitioner retired, but not since not received the return benefit.
Retired and then
not received the pension benefit, my lord.
It will accrue interest. Don't worry. Let his lordship come back. It will accrue interest. It will earn more.
Kindly heard the matter, my lord.
Next.
But on group 2 motion matter, my lord, the petitioner is not getting his pension, her pension on account of
petitioner
is not getting her. He's an assistant teacher in a secondary school, my lord.
Getting
her pension, my lord, on
accrue interest
on the ground of alleged. Kindly, if your lordship considers him on the ground of alleged overdraft amount, my lord.
It will accrue interest. You will earn more money. Wait for 14
it's a decided issue, my lord, as per Rafiq Masi, my lord.
নিজের মামলাই দিতে পারছি না
কিছু তো not the petitioner is not getting pension because of the fact that at the time of retirement he has allegedly overdrawn.
Sir, fact is not important. Important is urgency.
Urgency is that
you show me that you show me that petitioner cannot wait till tomorrow.
Well, every day for a pensioner.
Otherwise, it will be without jurisdiction. Look at the assignment note. Only urgent determination.
But the pension is not being released. Why is it not?
স্যার আমি আমার লিস্ট শেষ করতে পারছি না। Yes.
May I permitted to mention, my lord?
Yes, I allowed yesterday one motion, perhaps it is appearing. Those which really cannot wait for one day or extension of interim order, yes. Absolutely no requirement to explain.
5 minutes time. 5
Arre,
minutes time.
5 or 2.5 does not matter. It will accrue interest till his lordship comes. Next,
Extension of interim order, my lord. Interim order will expire on 30th July.
by his lordship.
Yes.
Tomorrow to be mentioned, extension of interim order, লিখে দেবেন, give notice to other side.
My lord, may I be permitted to mention? My lord, on an earlier occasion, I mentioned a restoration application.
It will appear, you have given the slip.
Yes, yes,
It will appear, there are maybe a bulk, it's appearing gradually, 5 or 6 per day. Don't worry, the moment you have filed, your limitation stops. Yes. Nakun,
That item 1, I appear for the petitioner.
My lord, I appear for the school authority.
This is the extension of interim order.
আরে একটু কি লেখাটা কি রয়েছে দেখেছেন, পড়েছেন? টেনশন অফ ইন্টারিম অর্ডার।
কি অবস্থা?
আরে জানি, আমি দেখে নিয়েছি। লিস্ট ইজ পাবলিশ, টেনশন অফ ইন্টারিম অর্ডার।
হ্যাঁ, টেনশন তো থাকেই।
Hearing matter. I tell you, hearing matters are regularly mentioned for inclusion. Whatever I allowed. Sir, no issues. You first, yes.
There are two kinds of urgency. One urgency for the lawyers and the other urgency for the clients.
Sir, how can I deny those days?
No, that is all right. Your lordship cannot afford Kolisada.
I understand.
Lordship cannot. Is it possible for your lordship in your lordship daily list? It is about 600 matters.
No, the finer part is elsewhere. Fine. But when I call on the list, hearing list, everybody mentions, include. The day I include and it is called on, nobody appears.
My lord, your lordship's determination and your lordship's word from that place, my lord, is final. There will be no adjournment of these first 10 or 15 matters. Everybody will come. With my experience of 58 years in this court, I say it.
Sir, you have seen the days. Is this the same day today?
Very recently, it has come to light, my lord. A ghapla about the printing of the list. How many lists are printed and how much money is given, how much is delivered here. It is in this seat of justice. In this seat of justice.
All right. All right. Yes.
This is regarding extension on 28th of March.
When it is expiring, tell me.
31st of this
Chalo. Ask.
Kindly record my objection.
Mr. Anjan Bhattacharya, learned counsel, appears for the petitioner. Mr. Devojyoti
Gupta.
Devopriyo Gupta, learned counsel, appears for the respondent numbers
456.
4226. Paragraph. None appears for the state. Paragraph. The interim order last extended on March 28, 2025 is still there till July 31, 2025. Poster. The interim order last extended stands further full stop. Tapal Likun, learned counsel for the respondent has vehemently opposed the extension. Paragraph. for the ends of justice, comma, the interim order stands further extended till
My lord, 1 week after vacation. March to July it was there last week.
August 30, 2020. August 30, 2025, or until further order, whichever
But
is
may I
earlier.
file my supplementary affidavit today?
I do not know, sir. File it before the regular bench. Because I do not know what is the supplementary affidavit.
If your lordship grant me
Kindly,
to file it, my lord,
Pray before his lordship. I do
Kindly
not
make-
know the matter. I simply extend.
my lord, kindly make the matter returnable on any date.
Sir, I am not the regular bench, sir.
Petitioner, your lordship.
I am for CSTC led by Mr. Bihani lordship.
This is a matter regarding
Checked up.
non-payment of 75%.
Checked up the order.
Yes, lordship.
Both of you checked up.
Yes.
Chal. দিয়ে দিন।
এই মাত্র করলাম।
অ্যাপিয়ারেন্স গুলো দিয়ে দেবেন। এমএস
সুস্মিতা দেবাসু।
মাইক্রোফোন সুস্মিতা দেবাসু আর ওদিকে হচ্ছে
সৌম্যজিৎ ঘোষ led by Mr. NC.
সৌম্যজিৎ ঘোষ led by Mr. নয়নচাঁদ বিহানি senior learned senior advocate. Next.
Should say.
Lord, I appeal for the state.
Checked up.
Yes, lordship. 25% has been paid
You are there for the state.
for the state.
Mr. Somnath Ganguly, learned senior advocate, appears for the state. আগেরটাই দিদি none appears for the state. ঠিক আছে? Next.
Lord, I appeal for the state. I am for CSTC.
Checked up. Mr. Somnath Ganguly, learned senior advocate for the state.
I'm also.
Great.
বলুন।
My lord, I am.
Next. Checked up. 5. No, who is appearing for the other side?
Sujit Shankar Kole, my lord, is appear on behalf of the respondent. I
Come on the next day.
my lord.
Come on the next day. Passed over for the day. কাল থাকবে. Give notice. Come on the next day. Tell him.
My lord, by phone.
Yes, whatever way, tomorrow it will be taken. Next. Yes, 6. Motion top.
I am for the statement.
6. Sir, you are there?
I am for.
You are there, sir?
Yes, I have stayed.
For?
Stayed, my lord.
Yes, sir.
My lord, I am finding the report in the form of evidence.
Wait. Let me see what is the direction. Have you served your report?
Yes, my lord, this is the report. I have served.
You have served. You will file exception. You are junior to Miss. Okay. তাহলে ফার্স্টে লিখুন Sardar Amjad Ali, learned senior advocate, appears for the petitioner. Mr. Your name, sir?
Mr. Bhakti Prasad Das.
Bhakti Prasad Das, learned advocate, appears for the state.
Along with Mr. Naranaran Ganguly, my lord.
With Mr. Where is he? He has come to court. He has come to court.
Yes, county.
With Mr. Naranaran Ganguly, learned advocate. Paragraph, Mr. Suman Basu, none appears for the rest of the respondents. Achha, paragraph. On the prayer of Mr. Bhakti Prasad Das, learned advocate, time to file report in the form of affidavit stands extended till today. Full stop. The report filed in court today is taken on record. Full stop. Copy has been served. Paragraph. Identically on the prayer of Sardar Amjad Ali, learned counsel, senior advocate for the petitioner, the affidavit in reply, affidavit in reply to the report is also taken on record. Yes, sir. You take your seat, sir. Let him complete that.
Number 2, my lord, I am appearing, my lord. Yes, I am on get some others, my lord. I'm sorry, my lord.
Nobody was there. Your junior.
I'm
was
extremely
also
sorry, my
there.
lord. Junior, I do not know who is junior.
All right, at not now. Not now. I'm in the midst of matter.
No,
I'm in the midst
I'm
of
not
a-
disturbing, my lord.
Didi, item number 2 for the state. Mr. Pantu Debray, additional government leader appears for the state. ওই নাম appears ছিল না ওটা কেটে দিয়ে ওনার নাম
ঠিক করে দেবে ও চেনে
next
ও জানে না extremely sorry, my lord.
My lord, your lordship will kindly come. Page 16 of my application, read application.
sir what is the matter sir just
My lord, your lordship,
understanding
that will do. Page 16, my
16
prayer A,
16
1-6. My prayer A.
16 sir wait yes sir
Read in the nature of mandamus,
yes
commanding the respondents to act according to law and forthwith take action to release family pension to the petitioner as a widow. Therefore, the applicant before your lordship is a widow. Late Amrituka, as per extended provisions of law and the orders, notification and terms of the order of the Honorable High Court.
why have they not released what is their reason why have they not released
Yes. My lord, the reason they say that, well, your family pension cannot be released until you pay an amount which has been paid to your account erroneously, until you pay back that amount, your family pension will not be granted to you.
Acha. So
Now the amount was given in my account. In my account. What was the conception? My husband died. Now your lordship will kindly go to the petition. Yes.
you are there in the matter so go and take your seat ওটার নাম লিখে দিন সুমন বাসু for
প্রিন্সিপাল অ্যাকাউন্ট্যান্ট জেনারেল
respondent number
Yes. My lord goes to
respondent number 5
page 3 of the petition.
page 10
Your lordship will kindly pardon me, but I may take your lordship to certain paragraphs of my petition in order to understand what is the
page 10
page 3. 3.
Yes.
Petitioner's husband, late Amrita Kumar Mondal, retired as operator cum mechanic, shortly called OCM, attached to the Block Development Officer, Kishannagar 2, on 30th September 2008. On his retirement on superannuation, late Amrita Kumar Mondal was receiving rupees 8,965 with effect from 1st October 2008, because he died on the 30th September.
Amrit Kumar Mondal was receiving. Acha.
Yes. He was a deceased government employee. I am his widow. Petitioner's family pension, provisional family pension, was sanctioned by the Department of Finance. Lordship marks provisional family pension.
Why was there any
Yes.
proceeding?
Yes, there it is. Provisional family pension was sanctioned by the Department of Finance in pursuance to Memorandum number 547, whereby employee of the state government enjoying higher scale of pay or higher fixation of pay in terms of interim order issued by this honorable court from time to time in terms of the order against which appeals are pending. Lordship finds appeals are pending. Such drawing of pay is purely provisional and subject to final result of the case of appeal. That appeal is pending till today.
Till today.
Yes, till today. It went even up to the Supreme Court, and thereafter Supreme Court came back, and this honorable court said, well, the pension will be provisional and it will continue till the disposal of the appeal pending before the honorable High Court.
The provisional pension will continue.
Yes.
Acha.
Petitioner respectfully noted late Amrita Kumar Mondal was one of the appellant in WBST arising out of a group of TA numbers so and so. The said appeal is pending before this honorable court for final disposal. It is respectfully submitted controversies regarding sanction and payment of provisional payment were raised before the Director of Treasury so and so. And by clarification memo, I am not taking this. Now, my lords, paragraph 7. Stated that 50% of provisional pension was sanctioned by an order dated 1/12/20 by the Block Development Officer till finalization of the pension case by the Account General, as he was a pay scale holder for pay scale lying pending before the Honorable High Court. That has not been decided, so final decision cannot be taken about my. Therefore, it was a provisional pension.
One second. It is respectfully stated that 50% of provisional pension, 50% of provisional pension was sanctioned by an order dated such and such by the Block Development Officer till finalization his pension case by the Accounts General West Bengal, as he was a pay scale holder for a pay scale please.
Yes. So, my lord, your lordship will
Pay scale lying pending before Honorable High Court.
Yes.
One second.
Lordship goes to page 22. The order is there.
One second.
Page 22. Annex P2. In supersession of the previous sanction order of the provisional pension by so and so in favor of Amrita Kumar Mondal.
Page
22. Annexure P2.
Yes. There is a bit acoustic problem in this room.
Yes.
It echoes. Yes.
Yes,
Page 22.
Yes.
Yes.
In supersession of the previous sanction order of provisional pension by so and so in favor of Amrita Kumar Mondal, this office, who retired from the government service due to superannuation on 30th September, revised sanction is hereby accorded towards provisional pension due to RO, that means revision of pension and accounts rules, in respect of Amrita Kumar Mondal. Therefore, the total amount provisional pension is rupees 8,965. You also got it?
Yes.
Why? Provisional rupees so and so only per month as per geo number so and so with effect from 1st October as ad hoc basis till the finalization of his pension case by the AG West Bengal, as he is a court case holder for pay scale which is still lying pending before the Honorable High Court. So the admitted position is that it is a
no, what is troubling me, provisional pension, I understand. Why 50% of provisional pension?
Because that was the order.
That was the
order. 50%. 50% should be. It has given, my lord. The notification was also there.
Achha.
That is the 50%. There is no dispute about that one. No dispute at any what. So this is the Block Development Officer that he is, and he is writing to, your lordship kindly goes to the bottom of that page, to see Amrita Kumar Mondal, ex-OCM. Page 22.
22, yes.
Yes. Page 22.
Yes.
Yes. Now, then your lordship goes to page 5 back. Lord, I am just taking, my lord, the synchronization of the entire case at page 5.
Absolutely, you proceed in your own way.
My lord.
Page 5.
Page 5. Unfortunately, petitioner's husband died on 5th February 2022, leaving behind his heirs, the petitioner being his widow, one married son and one married daughter.
There is no dispute about the claim of the widow.
No.
Family pension she is entitled to, and she is the widow, no dispute.
Yes. By order dated 27th October 2008, provisional pension was sanctioned to my late husband, having died on so-and-so. As the petitioner's late husband, Amrita Kumar, was the only source of income so-and-so, accordingly, by a representation dated 16th March 2022, petitioner requested Block Development Officer to sanction provisional family pension in favor of the petitioner. I am entitled to family pension after the death as a widow.
No doubt.
Yes. Respectfully submitted that by memo dated so-and-so, a petitioner was informed that as per inquiry report, Block Development Officer was informed about the legal heirs in respect of financial benefit only payable by government due to the death of Amrita Kumar. The names of the legal heirs, including their present address and the date of birth, was mentioned. It is all on record. Well, that report also I have.
You show me that communication. 21st December 2022.
Well, that will be at page 25.
25.
Page 25. At page 25. Doctor, got it?
Yes.
It is from the collector Nadia to the Block Development Officer Krishnagar 2. Subject legal heirship certificate of deceased Amrita Kumar Mondal. Who are the Archana Mondal wife?
As per inquiry report. Let us read the letter.
Pardon?
Let us read the letter.
Yes.
As per the inquiry report. Read, sir.
As per inquiry report of the Block Development Officer, by memo so-and-so, this is to inform him that the following person are legal heirs, family members in respect of financial benefits only payable by the government to the death of deceased Amrita Kumar Mondal, so-and-so, who died on 5th February 2022. Therefore, from this, my lord, report your lordship finds the confirmation of the heirs of the deceased, the date of the deceased, the heirs of the deceased, the date of the deceased, your lordship finds it.
Admitted.
Admitted. So all these are admitted position. Now, my lord, your lordship.
And Archana is also admitted.
Archana is admitted.
One second.
Archana is the petitioner before your lordship.
Archana's existence is also admitted.
And fortunately for me, my lord, the only, lordship will kindly pardon me, the only widow. This is also admitted.
Maybe that's the irony.
At least till today, no one has come.
All right.
Till today, no one has come on. So, my lord, goes to page 6, paragraph 14. No, paragraph 13.
So where is the troubleshooted now?
I will come to that, my lord. That is a simple, my lord. What is the trouble? That also very much, my lord, troubled me. What is the trouble? The trouble, I will come. Later on, it will be disclosed. Because my petition is very explicit, very clear. It is further submitted that the pension any benefit receivable by your petitioner upon death of her husband devolves, page 6, paragraph 13.
Yes.
That is my contention before your lordship. Submitted that pensionary benefit receivable by your petitioner upon death of her late husband, a deceased government employee, devolves as a right of property to which she has a legal right as a successor, not the petitioner herself as a government employee.
As of right. Absolutely.
But not as a government employee. I am not a government employee. My husband was a government employee. If he dies, I am entitled to get.
These are all the benevolent legislature, welfare legislature, policy decision of the state. So as of right.
I am deeply obliged, my lord. Provided the sense of benevolence is prevailing upon the bureaucracy.
All right.
Yes, bureaucracy happened. Otherwise, you should not have approached me.
All right, sir. Then where is
It
the
is also submitted
Hmm.
that pensionary benefit on retirement of a government employee is a statutory right
Absolutely.
on superannuation, but family pension. Upon death of government employee devolves upon the existing family members as on the date of the deceased as property. Because pensionary amount is a property.
I have held also.
Yes.
My judgment is there.
I remind myself of your lordship judgment. Yes. I've seen that. So, my lord, such denial is a violation of the principles laid down under Article 300A of the Constitution. Similar representation was also submitted by the petitioner to the Block Development Officer. Paragraph 15. Respectively, by an elaborate representation submitted to the District Magistrate Nadia. Then 7. In the said representation, it was stated, now a glaring discrimination. In my representation, it was stated that one Dipali Bishwa's widow of late Gaurhari is enjoying provisional family pension in a regular manner under Block Development Officer Krishnanagar 1. Mine is Krishnanagar 2 and it was Krishnanagar 1. But she is getting.
You are citing an example of discrimination.
I'm citing an example, my lord.
Of discrimination.
Yes. My lord, by that representation dated 26 July, that is paragraph 17, petitioner requested the district magistrate to take appropriate steps so that the concerned block may not harass a helpless widow like your petitioner. Respectfully submitted, not only this, my lord, I broke my head even to other quarters. A widow living in a remote village, or I'm being a little emotional, living in a remote village of the village of Nadia district. She even approached, paragraph 18, respectfully states he Biren Dey, President Central Committee of the Nationalist Government Employees Federation, by his letter dated enclosing therewith a number of documents, requested the district magistrate to give justice to Srimati Archana Mondal. Page 8. By an order dated 27 June, the Block Development Officer Krishnanagar 2, it is my Block Development Officer, informed that admissible pension of the late was revised to so and so. Petitioner's admission late husband was revised to 23,040 with effect from 1/1/2022. It was also ordered that area will be admissible as per direction and observation of the Finance Department pension branch noted in file number so and so, and the fixation is made provisionally subject to subsequent clarification and adjustment so and so. I've given that. Then paragraph 21.
21.
Paragraph A, bold from the blue. Upon me. Must you bewilderment said block development officer by his memo, petitioner requested that the excess amount of rupees 3,07,439 to be refunded to government head through challan, which is wrongly credited in your bank account. Am I
Why this wrong credit?
I don't know.
Acha, 1 second. It is in your page, paragraph 21. How have they dealt with?
Paragraph 21.
How have they dealt with?
Page P8.
How have they dealt with in their affidavit?
I'll come to the affidavit. There is no affidavit. It was a written instruction to the learned government advocate that was filed in the form of affidavit.
No. They have filed a report.
That is the report.
How have they dealt with it?
But it is the report. The report is with me.
So
Yes.
how have they dealt with it?
That is paragraph 21. Lordship kindly goes. Paragraph 21. At page 6. Page 6. Now, what is this? What is the nature of this document? Your Lordship will kindly see.
1 second, sir. Just 1 second.
Lordship kindly takes up page 4.
Page 4. Yes.
The undersigned. What is this, my lord?
Yes.
Subject.
Submission of parawise statement.
To whom? Is there any procedure in this High Court? I am asking to myself, my lord. I am not in anguish. I am only just showing my reverence to the procedure laid down by your Lordship's court. Can he? Can he? So it is a privileged communication between a client and the lawyer.
And the lawyer.
Can it be a formation of a basis of a affidavit? I have taken that point in my reply. That this cannot give any credence.
This nowadays.
It is not a question of nowadays.
No. Nowadays, the expression, at least we are fortunate to learn that privileged communication. Those concepts are gone. Nobody knows.
But the law is still there.
Absolutely. No.
Should we go down to the law, or it is the whims and caprice of a particular client or the lawyer? A question I am asking to myself.
It is always, sir.
There are not much more time left for me. No, personally.
We were also taught that these are privileged communication.
Yes.
When can be gone into evidence? The fundamental.
Yes. My lord, Lordship will kindly pardon me.
Court can take cognizance.
My lord, kindly pardon me. Perhaps I claim that privilege from this court. That before I say my final farewell to this institution, I show my respect and reverence to the law laid down by this court and the other laws of this country.
Law of the land.
Law of the land. The delicacy, the distinction of a High Court of Justice. The delicacy and your Lordship has seen me while your Lordship was here in this side. I cannot cheat with myself. I can cheat with my client, but not before the court. Lordship kindly pardon me, my lord, for this. Anyway, so the undersigned, the block development of him being well conversant with the instant petition, so and so. But what is the privileged communication? Your Lordship asked me, what is paragraph 21? Lordship will kindly find that paragraph 21.
Kindly take paragraph 24, page 6.
Page 6, yes.
Last paragraph.
Page 6.
Last paragraph.
Last paragraph. In respect of para 24, the undersigned wants
No,
to.
first, sir, let us read para 21.
Yes, para 21.
Page
In
6.
respect of the undersigned is strongly denying the facts. Want to say that an amount of rupees so and so was credited in the account of the petitioner, out of which it is arrived that an amount of rupees was wrongly paid. আরে বাবা কার টাকা কাকে দিচ্ছিস কেন দিচ্ছিস? You are the custodian of the money, the public money. I'm not supposed to know as to what is the amount coming to me. I've said that. Well, I don't know what is the money you have given. I was under the impression that I was getting the family pension.
No. Your client will know this much. Your client will know this much, that yes,
After the
a
date,
particular quantum is being credited to his bank account.
yeah, that's all.
That's all. It may be 15 rupees, it may be 25 rupees.
And for what purpose?
Naturally, it regularly comes in. But your client, it is not always possible to know that what is admittedly to be paid.
Yes.
What quantum?
Yes.
She knows she knows that she is entitled to get family pension for survival.
Yes.
She gets it. Matter ends.
Provisional family pension.
Whatever.
Yes.
Not a nomenclature.
Yes.
A quantum has to come, it has come. But what is the correct quantum?
What is the correct quantum and for what is it to be paid? Because I know I'm a widow.
That's right.
I know I'm to get
Correct.
a provisional widow pension. Widow pension, not as a government employee,
Correct.
but as the widow of my deceased husband who was a government employee. Therefore, it is on your part, it was your obligation to let me know, well, this is the money that is being given to you. This is the total amount that you are entitled to. I don't know anything. Now, all of a sudden, when I say that, kindly give me my family pension, they say, no, you pay back that money. Am I responsible? And I do not deny that the money was there. But I was not aware, because I was not made to be aware as to what is the amount for, what is the total amount that is being credited in my account. Well, if somebody else is giving me money, 10 rupees.
So your client has never received.
Never.
No. This quantum was there. This quantum was credited to whose account? Your husband's account?
My account. In the account, yes.
No. I'm saying, during the lifetime of your husband.
No, it is said, my lord, it is said that an amount of rupees so and so was credited.
Where from you are reading?
To the account of the petitioner.
Where from you are reading?
Paragraph 21.
Let us read it.
Paragraph 21.
And in respect of para 21, the undersigned strongly denying the facts. Wants to say that an amount of 353,656
yes,
only was credited to the account of the petitioner on such and such, out of which it arrived at an amount of rupees 3,07,000 was wrongly paid to the petitioner. Acha, copy of bill amounting to such and such.
So in my account it is given.
And so the petitioner was asked to refund the excess amount of rupees Ato. But on the other hand, the said letter memo dated, the petitioner was also asked to apply for family pension, but the petitioner has not responded.
Totally false. Because number of times I have shown that.
Now, it might so happen that there may be some statutory format or prescribed format. That I don't know.
No.
That I don't know.
No.
But even then, they should have told you
that simple question comes. Where did you get my account?
No, even if it is there.
One of the question is, where did you get my account that you are depositing money? You have made sufficient inquiry. As earlier I have shown, my lord, from their own document. Now, my lord, what is my answer to this? That this money was admittedly, I didn't deny it.
No, it's reflected. in your
No,
passbook.
my lord, my explanation I have given to your lordship, subject to your lordship's approval or disapproval. Page 9, paragraph 22.
Page?
Page 9, paragraph 22.
From the report. No, petition,
no.
petition.
My petition.
Yes.
Yes. The respondent authorities have been crediting from time to time diverse amount in his savings account. As mentioning, mind that one, it is savings account. Where did you get it from? Did I? Certainly, my account you must have known. As pensionary benefit of the widow of late, bereft of any particulars regarding the credited amount,
Absolutely.
the petitioner bona fide believed that the credit was on account of her family pension. Because
Correct.
before that, you have already made an inquiry. My fault? If it is my fault, then your lordship throw me out. This is what you say, and you see that I didn't make any representation. I didn't make any representation. That is what it say. A privileged communication in the form of a affidavit. Then, my lord, much surprise was awaiting for the paragraph 24. Much surprise was awaiting for the petitioner when she received memo number so and so regarding the fixation of pay in terms of so and so in favor of the petitioner. That is 2/2/24. 2/2/24, yesterday. What was the letter of the learned, of the esteemed, my lord? That letter dated (27/9/2023), Block Development Officer, and it is in 2024. District Magistrate regarding the fixation of pay in terms in favor of the petition.
Where you are reading?
Paragraph 24 at page 9 of my petition.
Subject.
Page 24.
That's right. Subject. Fixation of pay in terms of WBS, ROPA.
Yes.
With reference to
in favor of the petitioner as provisional pension. As provisional pension holder. With reference to so and so. So district magistrate, my lord, the district magistrate was writing this. Your lordship, next gate, my lord, at P9. It is P9 where the letter of the district magistrate is there. At page 46. At page 46. At page 46, P9. My lord, it is from the district magistrate to Block Development of Kishanur to my video. To my video. District magistrate writing on 16th February 2024.
To your employer.
Yes.
Your employer.
Yes. Before that, he has said, deposit the money. The district magistrate.
Before that,
the Krishnagod video wrote to me. District magistrate regarding.
Page.
I've seen that, my lord. At page 20, paragraph 21 at page 8. This was in the year 2023, and here the district magistrate is writing in 2024. My fault. Is there any coordination? I'm asking to myself. With reference to subject mentioned in code herewith. Application provision pension so and so. Rupa 19 Srimati Archana Mandal. You to take necessary action. Does it hold gold on your mouth to say that I did not make any representation? Your DM is saying, here is the representation, consider it. Consider it. A hapless woman, a citizen of this country, and it fell from your lordship that pension is a beneficiary legislation. It's a benevolent legislation. Why? Because these poor souls, those who are not here in this world,
For survival.
constituted a constitution saying that, well, India is a welfare state. A welfare state. Well, I do not know for whose welfare.
No, so, no, the welfare legislation, that is no doubt about it. And as far as liberal construction for the beneficiary,
Yes.
so
So,
these
my
are
lord, your
there.
lordship. Your lordship is fine, my lord.
Subject to hearing you further.
Yes.
Subject to hearing you further.
Yes.
Just let me hear your learned friend once.
Yes.
What do you, huh?
If your lordship calls me, only one paragraph I will show, my lord.
Yes.
Then, my lord, if further necessary, then I will certainly come.
Show me.
At page 10.
Writ petition.
Page 10, writ petition. Paragraph 25. From the above memo P9, it is further clear and evident, not only in casual and negligent manner, but in a cavalier fashion, everything is being done without application of mind, far less sympathy, and oblivious of their obligation to resolve the issue of family pension. According to law, the respondents have acted to the detriment of the interests of the petitioner as well the state. I've covered both. Sumara, on my father lordship. On father call from your lordship.
Thank you.
My lord,
Take the microphone. Listen to me
my lord,
first.
petitioner is entitled to get the family pension. It is no doubt, my lord. That's why
Take microphone, sir.
petitioner is entitled to get the family pension. It is no doubt. That's why he repeatedly asked to submit some necessary paper, but he denied. This is the position, my lord.
She has denied to submit the necessary
paper for family pension.
So your stand is now not return of money.
That's why, my lord, as your lordship may fit and proper.
No question of as your lordship. What is your submission, sir?
Once widow has paid, that is I don't know, my lord, what it.
I can't follow you, sir. What is your argument?
My family pension is ready.
Absolutely. That's a very fair stand on your part. It has to be paid. Fair enough.
Money return, our money return.
Your authority took a stand that unless you return 3,07,000 and odd, we will not pay.
Yes, ma'am.
Right? Now, your authority took a stand, unless you return 3,07,000 and odd, we will not pay. Right? Now, that 3,07,000, which was part of 3,53,000, was credited to petitioner's bank account. এই বড় বান্ডিলটা নামান তো
সেভিংস ব্যাংক অ্যাকাউন্ট এসবি অ্যাকাউন্ট সেভিংস ব্যাংক
petitioner's account. হ্যাঁ, এটা সাহেবকে দেখতে পাচ্ছি না।
পোস্টাল অ্যাকাউন্ট
353,000 was paid by crediting petitioner's account.
Yes, ma'am.
So unless you have a knowledge of petitioner's account and unless you are satisfied with all records, you ought not to have paid that. Think rationally, sir.
Yes.
Let us resolve the issue. Let us resolve the issue. The law comes later.
Yes, my lord.
Let us resolve the issue first. So unless you know that account, unless your authority is satisfied with all existing papers, it ought not to have released 353 and by crediting his account.
Yes, my lord.
So there cannot be any dispute with regard to the payability or receivability by her,
Yes, my lord.
right? Question is, what is the correct quantum? Question is, what is the correct quantum? Right? You show me from your report that, let's say, 10 taka is the correct quantum. Show me from your report that 10 taka is the correct quantum. By mistake, rupees 15 paid. Show me that. First step.
Not stated, my lord.
Huh?
In the report, there is no statement.
Not stated? All right. So it is not possible for the court to ascertain whether at all any excess amount paid or not. Well, I don't know whether it is 10 or 15 payable. Correct? But payability is admitted,
Yes.
both in law and facts. Law, it is admitted because it is provided. Facts, it is admitted because you have already credited whatever amount to her bank account.
Yes.
Right. Question is of refund. What more you want to submit? First you tell me, then I will ask some question to Mr. Ali. Tell me what more you want to submit. But of course, from record, not beyond the record. Tell me.
Hello. At present, I cannot say it without instruction.
Sir, no question of at present. You have used an affidavit.
Yes, my
So
lord.
you have to say whatever you want to say on the basis of your affidavit.
Yes, my lord.
Right?
Yes.
You say me, you tell me what is your defense in from your affidavit.
When about the excess payment, my lord.
To come to a finding of excess payment, first the court must know what is the actual quantum to be paid. So what is your submissions on record?
Refunded paper. The quantum of concession, there is no hints.
Take the microphone.
It is not mentioned in the quantum of payment in the report.
Not mentioned?
Not mentioned.
Very well.
Only refund is mentioned.
Mentioned, I have seen that because I have read, by this time I have read entirety, your report. What would you do if it is not there? You are the creature of instruction. What would you do?
As your lordship may fit any.
All right.
According to.
Mr. Shuman Bose?
Our role will start only when the office.
Releasing. Releasing is your role start.
Unless they send the documents, yes.
Correct. Unless they send
the pension papers to our office after due sanction.
Correct.
Because till now no pension paper has submitted
all
to
right.
our office.
So admittedly, deceased had not received a single farthing on account of family pension. 7 except that 353.
We cannot say right now because nothing has been sent to our office, madam. You could inspect the records. Once the pension paper will be made ready and then it will be sent to our office, my lord, for sanction. For use of issuance of the authority for family pension. Not this. So what transfers from the page 45?
Take microphone.
What transfers from page 45, my lord? It appears that
45 of
the writ petition, my lord.
yes.
My lord, so far I have understood, not subject to correction of your lordship, my lord, that the petitioner is entitled to provisional family pension, but they have calculated family pension and this was the entire amount. And they have asked for a refund of the excess amount.
Why provisional family pension? Because of the pendency of the appeal.
Yes.
Because of the pendency of the appeal.
Yes.
The actual family pension could not be paid because of the pendency of the appeal.
Because the pension of the employee has not been settled.
I am not at all interested. What is the issue involved in appeal? It is also admitted by Mr. Ali that since the appeal is pending, I cannot claim full family pension. So I am not at all interested. What is the issue involved in appeal? Since when you have not received, sir, family pension? Since when you have not received?
Since when?
When you have last received?
Just after it. Well, after the death of my husband. After the death of my husband.
From that date, you are entitled.
Yes.
But you have not received any amount other than this 353.
That is the amount which they have been given to, whether it is
I'm not on that. I'm saying that monthly 8,000 or what?
Yes.
Whatever you are entitled to according to them.
That is what it is.
So that amount has not been paid since when?
My lord.
Suppose, let me be very candid.
Yes.
Suppose here and now I shall direct them. Sir.
Yes.
Suppose.
Coming to that. After the death of my husband, I did not get any family pension.
Okay. So why this 3,50,000 was paid?
They can explain only.
Oh, only a lump sum paid and thereafter nothing paid.
I know. That is why I say that you decide. My lord, I will beseech your lordship to kindly see, my lord, my reply to their affidavit. My lord, only 2 paragraphs I will. Has my learned friend.
Yes.
If my learned friend has concluded, my lord, that on. Lordship kindly says. My affidavit in reply. Page 2. Page 2. I will beseech your lordship to consider this also.
Show me which paragraph?
Paragraph 2.
Yes.
Purported report contains nothing but perverse statement of facts in respect of the writ petition by the respondent block development officer to the learned state advocate to defend the case. Then, lordship says, evidently clear that no pleading or averment made in the writ petition has been verified. But what is the substantive question? Paragraph 4. Paragraph 4. The substantive issue that requires to be decided is whether provisional pension determined under so and so would devolve upon the widow of a government employee on death as family pension or provisional family pension. What are you giving to me?
That question I cannot decide because the appeal is pending. That I cannot go into.
I am not asking for that. I say, what is the nature of this payment you are giving me? Whether it is a provisional family pension
or the family
or a family
or a
pension.
full strength family pension. Acha. Now you come to your writ petition and show me that according to you, this 8,000 and odd is admitted.
Yes.
Kindly come to paragraph 2.
He himself have admitted.
So you come to paragraph 2 from your writ petition.
Paragraph
2.
Yes. Yes. On his retirement superannuation so and so, is a provisional pension will be 17,930. But admittedly, it has been revised because of the report of the district magistrate under the revision of pay and allowances rules. It had much more exceeded. It had much more exceeded. So it was at the time of my date, of the death of my husband. Now what is the amount? How do I know it?
It's P7 or page 44, there is a calculation. Page 40.
Writ petition, page 44.
Yes. The letter of the block development officer.
Page 44. Yes.
Revised provisional pension will be 23,040. It is on there at saying.
Provisional will be 23,040.
Yes.
And 50% of that
will be provisional family pension.
That's right. That will have to be paid.
Yes.
Till the appeal is decided.
Yes.
I couldn't follow my letter.
Come to page 44.
Yes, I am on page 44.
Let us take the round figure. 23,000 is payable.
Yes.
Because of the pendency of the appeal, 50% of 23,000
yes.
comes to 12.5. Sorry, 11.5.
Provisional pension, my lordship kindly sees that order. Provisional pension, my lord, towards the middle of the citation.
Right.
In compliance so and so,
not family pension.
in compliance so and so, then it is the block development officer writes. The provisional pension of Amrita Kumar, who was superannuated so and so, and died on so, is revised.
Where from your reading?
Paragraph 44.
Page 44.
Middle portion.
Page 44.
Correct. In compliance of memo dated such and such of additional secretary such and such to the additional district design read with observation of finance department such and such, the provisional pension of late Amrita Kumar Mondol, who was superannuated from his service on Atho and died on Atho, is hereby revised.
Revised.
Right. I am also taking that.
Yes. As on 1/1/2020.
Para 2 of illustration of such and such, Government of West Bengal Finance, following manner. And lastly, it came to the figure of 23,000.
Yes. 23,000.
Right.
Yes.
So
area will be admissible
Huh?
towards the bottom. After that, my lord, area will be admissible.
Absolutely.
Yes.
Area will be absolutely admissible in terms of the revision made from time to time.
That has been given. Page 45 reflects. Not
Area will be admissible.
Let them answer. Do you give it to me as a family pension or a provisional family pension? Family pension and provisional family pension are not same.
No, not same.
Yes.
Not same.
Pension is altogether under the ROPA, revision of pay and allowances rule under the date come retirement benefit rules. I am here, you teach me. Widow pension is under the date come retirement benefit and rule. But family pension that is being given, it was to my husband. He died. He was receiving pension.
That's
provisional pension.
Provisional pension.
Provisional pension.
So 50% of that you will be paid now.
It will be paid to me.
You will be paid.
Therefore, now the question is, what amount you have paid to me? That you are asking me to refund 3 lakh or so.
Let me express my mind.
My lord.
My lord. To all of you.
My lord.
I have a mind to pass an interim order, subject to hearing you all of you further.
My lord.
If you say something, your submissions, I will definitely again hear you.
My lord.
Now itself. What I am proposing, I will pass an interim order. Appropriate officer, whoever it is, shall calculate the actual quantum to be paid to you on the basis of the existing facts that the appeal is pending since the next date of death of the husband. Next date of death of the
Correct.
husband.
And pursuant to this notification by order. The revision.
To?
Revision.
Yes.
Yes.
They will take care of this.
Yes.
I'll record that.
Yes, my lord. I know, my lord, I have no escape from this court. Yes.
No, I'll record that. And this exercise shall be done within 15 days from communication of the order. Immediately within 1 week thereafter, you will be communicated with a written communication. Right? And they shall start the family pension, whatever, according to their admissible amount.
Clarifying the nature of the pension.
Provisional family.
Whether a family pension, whether a family pension, whether a provisional pension, as per the order of the court.
Provisional
Since the husband was receiving provisional pension, so unless the appeal is disposed of, my lord, and pension case is finalized.
So on the basis of provisional, it will have to be calculated.
Yes.
The lordship is correctly assessing that 11,000 and half, my lord, will be the
11,000, and kindly come to page 44.
Page 24.
44.
Yes. 44.
So last digit is 23,000.
Oh, yes.
So you will have to be paid 11,000 and half. Right?
As what?
Huh?
As what?
50% of the provisional pension.
Provisional pension, my lord. Provisional pension and provisional family pension. Family pension means kid money that as widow I will get it.
So so I will say,
my lord,
on the basis of the provisional pension last received by the husband.
My lord.
Last received by the husband.
I am deeply obliged.
Taking that into account along with this revision. Whatever admissible pension, family pension has to be paid now.
My lord.
They will have to pay it. Right?
My lord.
Achha. Insofar as arrear is concerned, on that rate, whatever will be the time-to-time division, they shall also inform this court. Right? I will keep the writ petition pending.
My lord.
Correct? They will go on continuing pay until the appeal is disposed of. Thereafter, the writ petition will be finally taken.
I'm deeply obliged. My lord, I have no grudge, my lord. I'll be highly obliged, my lord. Let them
provisional
say.
pension cannot be stopped, my lord.
Absolutely.
My lord.
Ashu. Take your seat.
Page 45 should have carried a calculation, my lord.
Huh?
Page 45 should have carried a calculation, my lord. What have
44.
44, there is a calculation. Page 45, what is the excess amount? What is the actual amount?
6 পরে হবে. Excess amount, return, I will keep all those questions open at the time of final decision of the writ petition, because that will depend on the result of the appeal. পরে হবে বাবা, আগে she must survive.
Yes.
First, she must survive first. Mr. Shuman Mosh, you assess this code, or both sides are, or let them take their seat. I'm recording. So facts. This is a writ petition. And first উপরে সব আমি লিখে দিয়েছি. This is a writ petition filed by the widow of a state employee who was an employee under the respondent number 2. alleging that the family pension payable to the widow has not been paid since after the death of her husband, deceased husband, who was the employee of the respondent number 2. Paragraph. The deceased husband, Amrito Kumar Mondol, A cap, K cap, M cap, bold করবেন ব্র্যাকেটে for short Amrito, was superannuated on bold September 30, 2008 and died on February 5, 2022. Bold. Paragraph. On the plea of pendency of an appeal arising out of a challenge to a government policy decision with regard to payment of pension, comma, the deceased husband Amrito received provisional pension as a policy decision of the employer. Full stop. Such policy decision was not challenged by the deceased husband during his lifetime, and he has accepted the provisional pension. Paragraph. Sardar Amjad Ali, learned senior advocate appearing for the petitioner, referring to a government order dated June 27, 2023, Annexure P7 at page 42 to the 44 to the writ petition, submits that the state authority that the employer stroke respondent number 2 has admitted the revision of family pension payable to the petitioner on account of Amrito. And according to the said document, the revised provisional pension as on January 1, 2022 was admitted to be rupees bold 23,
January 1, 2020.
no, 2022. Last one?
Right on 2022. Is hereby.
I will take the last date. I will take the last date. See, it's a benevolent legislation. As far as much as benefit can be given, has to be given. কি বললাম?
On account of and according to the said document, as on was admitted to be rupees.
Admitted as rupees to be admitted as rupees 23 bold didi, huh? Rupees থেকে 23,040. Full stop. Sir, show me that document. Show me that document. Your junior will do.
My lord.
Show me the document on the where they have taken the plea, excess payment you return, then I will pay. You take your seat, Mr. Ali. Sir, you take your seat, let your junior do. Page? Page 45. Full stop.
জোরে বলো না কেন ঠিক আছে
Referring to another document dated September 27, 2023, Annexure P8 at page 45 to the writ petition. Learned Senior Advocate Sardar Amjad Ali for the petitioner submits that on the plea of crediting an arrear bill of Amrito for the period January 20 to June 23. Comma, an alleged excess amount of rupees 307,439 already credited to the bank account of the petitioner unless is refunded to the government following the due procedure the family pension could not be paid to the petitioner. First. The principal contention of the petitioner on the basis of the said two documents and other records or other materials on record is that when the said sum of rupees 307,439 to be an alleged excess amount was credited to the bank account of the petitioner, comma, it was neither within the knowledge of the petitioner whether it was paid in excess or not, and the petitioner even does not admit the same that the said amount was in payment of in excess. Said amount was paid in excess. As no calculation was provided to the petitioner by the respondent number 2 with regard to the correct quantum of family pension payable to the petitioner. Poster. Paragraph. Then its senior counsel, Mr. Ali, then submits, Amjad Ali then submits that to receive pension and or family pension by the widow, to receive pension by an employee or to receive family pension by a widow is a matter of right. After the superannuation of the employee. Payment of pension is a result of a benevolent and welfare legislation of a welfare state for survival of the employee or its family members after superannuation. Paragraph. In the light of the above, petitioner claims the admissible family pension payable to her in accordance with law. Paragraph. From the report on affidavit submitted on behalf of the respondent number 2, it appears that a parawise comment provided to the learned advocate for the respondent number 2 is appended thereto as annexure R1 at page 4 to the report. The same document dated September 27, 2023, as already referred to above, is also appended to the said report as annexure 2 at page 13, R2 at page 13 to the report. First. Nowhere from the report it appears the calculation in support of the plea taken by respondent number 2 showing that the said alleged excess payment first. Learned advocate কি নাম যেন Mr.
Bhakti Prasad Das.
Bhakti Prasad Das, appearing for respondent number 2, submits that in view of the pendency of the appeal, Amrito being the deceased employee, was not paid the full pension, but was paid the family provisional pension. Paragraph. He also submits that in view of the said excess payment being made, alleged excess payment being made, the petitioner has not been paid with the family pension. Mr. Shumon De Basu. Learned counsel appearing for respondent number? কত?
Not 5.
5 submits that his client has a very limited role to play as of now. Unless respondent number 2 sends all papers and documents, they cannot take any further step for payment of family pension to the petitioner. Paragraph. After considering the rival contentions of the parties and on perusal of the materials on record, at the outset, this court reiterates that the claim on account of family pension by the widow is a matter of right. Which flows from the death of the concerned employee, concerned employee, who was the husband of the petitioner. The welfare legislation should be construed and interpreted in a manner as liberal as possible in favor of its beneficiaries. Of course, subject to the restriction that the beneficiary must qualify the criteria to receive the benefit. Paragraph. In the facts of this case, the admitted position is that the petitioner, being the widow, is entitled to family pension. The government order dated, the said government order dated June 27, 2023, at page 44 to the writ petition, clearly shows an unequivocal admission on the part of the employer, respondent number 2, that the revised provisional pension as on January 1, 2022, on account of Amrito, was rupees 23,040. Full stop. The next document dated September 27, 2023, at page 45 to the writ petition, also shows an unequivocal acceptance on the part of the respondent number 2 and the state government and the state that petitioner is the widow of the employee of the of Amrito, and an alleged excess payment was credited to the bank account of the petitioner to an alleged extent of rupees 307,439. These facts clearly and admittedly demonstrate that the claim of the petitioner for family pension is a lawful, genuine and bona fide claim. Full stop. Paragraph. Now the question is, in view of the pendency of the appeal and in view of the claim of the state that an alleged excess amount has been credited, whether the family pension can be stopped. The family pension payable to the petitioner in accordance with law can be stopped or cannot be paid. Cannot be paid. Full stop. Paragraph. The concerned appeal is pending till today. Full stop. In absence of any calculation in support of the said alleged excess payment being credited as claimed by the state, the respondent number, who shall quantify? Two. The respondent number 2. Respondent number 2. Respondent number 2 will calculate.
Respondent number 2 is the
Respond কি বললাম?
In absence of any calculation support as claimed by the state.
Comma, the respondent number 2 is forthwith is directed by taking into account the said government order dated June 27, 2023 at page 44 to the writ petition to quantify and calculate and quantify the actual family pension. আচ্ছা এইভাবে লিখুন, পড়ুন। And pendency taking into account দুটো জিনিস নেবে, this one and the pendency of the subject appeal, comma, কি বলুন, পড়ুন। After taking into account.
After taking into account, state government order dated and pendency of the state
June 27, 2023 at page 44 to the writ petition and pendency of the subject concerned appeal, comma, the amount payable to the petitioner since the next date of death, এই কথাটা bold, of Amrito from time to time and shall inform the same in writing to the petitioner with the detailed calculation positively within a period of 3 weeks from the date of communication of this order. Paragraph. 3 weeks to bold. T cap, W cap. Paragraph. Thereafter, the respondent number 2 shall immediately start payment of the start thereafter. Now, so payment to you will do.
Payment will be there, but authorization should be issued by our office on the.
Key next step.
Next time they will prepare the pension file, my lord.
Prepare the
pension file, pension case
Achha.
with the proper sanction.
Okay. Thereafter, the respondent number 2 shall immediately prepare the entire pension file on account of the petitioner in accordance with law and send and transmit the same to the respondent number 5 positively within a period of 2 weeks. Positively within a period of 2 weeks from the date of the said calculation to be completed by the respondent number 2. Paragraph. It is needless to mention.
Respondent number 5 should clear, my lord, within a particular period.
Paragraph. The respondent number 5 shall then clear the entire payment.
We will authorize the payment. Authorize the payment.
Payment korbe dake.
State. The employer of the state.
You have to send it to somebody else.
The authorization will be issued by our office, my lord, regarding the payment. The payment will be made by the state, by the employer. Yes.
That is respondent number 2.
But if it is the provisional family pension, my lord, no sanction is required from the respondent 5. It is provisional. For provisional pension, office of the principal account.
এক সেকেন্ড কি লিখলাম পড়ো
and transmit the same. The petition.
Respondent number 5. Paragraph. On perusal of the said pension file, next data, paragraph. The respondent number 5 shall
issue the authorization.
Issue the necessary authorization in accordance with law positively within a period of 2 weeks.
4 weeks.
3 weeks. মাঝামাঝি থাক।
So, my lord, the whole question is, this will be a tug of war between the state, the accountant general, and also the.
Sir, the writ is pending. Why do you worry? It will be pending.
Let the accountant general, or I couldn't follow really what is the state of the. The accountant general said that they have to clear it.
No, they say that they have to authorize it.
We have to authorize whom?
I will make it clear.
Authorize whom?
আচ্ছা আবার পড়ুন ওই জায়গাটা রেসপন্ডেন্ট নাম্বার 5 I said that the necessary কি বললাম পড়ুন
Immediately prepare the entire pension file on account of the petitioner in accordance with law and send and transmit the same the respondent number 5 positively within a period of 2 weeks from the date of the said calculation to be completed by
তারপর পরেরটা
perusal of the said pension file. The respondent number 5
shall issue the necessary authorization in accordance with law in favor of.
The treasury is not party here, my lord. So the treasury, concerned treasury. Disbursing authority.
In favor of the disbursing authority being the jurisdictional treasury officer.
One of the discharging officer, in the eye of law, the discharging officer is the respondent number 2.
এইটা তো ভাই procedure side I don't. Tell me. Tell me what.
Discharging officer.
So far,
You should know it. Who is the discharging officer?
All right, let us solve the problem.
Yes.
Let's solve the problem.
it should be the treasury when all payments.
Take the microphone.
It should be the treasury when all payments are made through treasury only, my lord.
That means the treasury.
Well, can you make it either?
Jurisdictional treasury officer.
Your lordship, can you make it?
The district magistrate.
Whoever.
Yes. My lord, unless and until it is specifically said, my lord, there is a my lord loophole.
They will not do that. Jurisdictional treasury officer, I have said, sir.
Jurisdictional treasury.
Or disbursing authority.
Jurisdiction, আচ্ছা কি বললাম আবার পড় দাঁড়ান আপনি এটা নিয়ে পড়ুন তাহলে সবাই শুনতে হবে এগুলো খুব টেকনিক্যাল এগুলোতেই ভুলটা হয় আইনে অসুবিধা নেই
On perusal of the said pension file, the respondent number 5 shall issue necessary authorization in accordance with law in favor of the disbursing
in favor of the jurisdictional disbursing authority stroke jurisdictional treasury officer
For payment of regular family pension. For payment of regular family pension.
for payment of family pension.
So far, it is if it is a provisional pension or family pension.
You don't know to whom it is to be given?
Let's see.
If it is provisional, no sanction is required.
No sanction is required.
If it is a regular family pension, then our authorization is required.
আচ্ছা ঠিক আছে wait sir.
Not necessary for them.
No. He is saying the procedure, sir. He has not said anything. He is saying in the event it is provisional, no sanction from respondent number 5 is required. I will.
He doesn't have.
I will. Listen.
Absolutely. I am saying.
Yes.
কি হয়েছে?
on perusal of the
No, it is on that question of my lord, your lordship. Lordship will kindly remember. And it is on that question as to who is the appropriate authority. So Liaquat Ali, who was in charge of the finance ministry at the time when the.
All right. Let me complete.
Yes.
ভুলিয়ে যাবে না তো। কি
on
বললো?
perusal of the said pension file, the respondent number 5 shall issue necessary authorization
Please listen, sir.
in
Please listen. কি?
On perusal of the said pension file, the respondent number 5 shall issue necessary authorization in accordance with law in favor of the jurisdictional disbursing authority oblique jurisdictional treasury officer for payment of family pension.
For payment of
Regular family pension.
regular family pension. Full stop. In the event it is decided by the respondent number 2 that it should not be it is calculated in the event it is calculated by the respondent number 2 that it will not be a regular family pension
Provisional family pension.
but a provisional family pension, then the respondent number 5 will have no role to play. Full stop. Paragraph. ওইখানে আরেকবার চলে যান ওকে টাইম দিতে হবে নাহলে পেমেন্ট আটকে যাবে কি বললাম
যেখানে disbursing authority
ইন দ্য ইভেন্টের আগে
in the event আগে তো এটা on perusal of the said pension file, the respondent number 5 shall issue necessary authorization in accordance with law in favor of the jurisdictional disbursing authority oblique jurisdictional treasury officer for payment of regular family pension.
Pension positively within a period of 2 weeks from the date of receiving the pension file from the respondent number 2. Full stop. তারপরেরটা পড়ো in the event.
In the event, it is decided by the it is calculated by the respondent number.
In the event it is calculated. পড়ুন
It is calculated
by the
respondent number 2 that it will not be a regular family pension but a provisional family pension. Then,
comma, then the respondent number 5
will have no role to
play, but it shall communicate the same to the respondent number 2 within the said period of 2 weeks. To enable the respondent number 2 to make payment, right? Then payment ta ke korbe?
Disbursing authority, I believe through treasury, my lord. I have to take instruction, my lord. It should be through treasury.
All right. Paragraph. Who will pay?
Review. Respondent number 2. Respondent number 2.
4.
2. Respondent number 2.
Pay.
BDO.
Who shall pay?
Yes.
Paragraph. Depending upon the steps to be taken by the respondent number 5, as mentioned above, the respondent number 2.
2. Block Development Officer, Krishnagar 2.
Mr. Shuman Basu, respondent number 2 shall make payment.
In page 41, the document annexed by my learned friend, senior friend, is disbursing authority. Is mentioned as disbursing authority.
কোথায়? Page
41.
ঠিক আছে বাবা, চলো।
Disbursing.
The respondent number 2 and or the jurisdictional disbursing authority.
Respondent number 2 is asking me to pay refund.
ঠিক আছে।
It is he.
All right. The respondent number 2 shall pay the amount payable to the petitioner, including the arrears, since the next date of the death of the employee husband, deceased employee, till আজ এটা কি মাস? জুলাই শেষ হচ্ছে কবে? আজকে কত?
আজকে হচ্ছে 23।
ও এত কিছু করতে করতে হয়ে যাবে। till July 31, 2025, and thereafter shall continue to pay the month by month family pension on and from August 1, 2025, and shall continue to go on paying without any default, but positively within the 7th day of every calendar English calendar month. 7th day of English calendar month.
Provisional family pension. Provisional family pension till disposal of the appeal.
That's right. I'm saying that.
You don't have any jurisdiction.
No. Question is, respondent number 2 will decide.
Yes.
You don't
He
have
shall.
jurisdiction.
Respondent number 2 will
On
decide.
treatment.
He will say it is provisional.
Yes.
So that will be paid. Full stop. কি বললাম? আবার পড়ো।
Thereafter shall continue to pay the month by month family pension on and from August 1.
Family pension as will be decided by as will be calculated by the respondent number 2. As will be calculated by the respondent number 2.
Respondent number 2 on and from August 1, 2025.
এগুলো বোল্ড কিন্তু সব দিদি।
August 1, 2025, and shall continue to go on paying without any default, but positively within the 7th day of English.
Every 7th day of every English calendar month. Paragraph. The paragraph. This is an interim order in this writ petition. Full stop. Paragraph. The question of payment of full family pension and the interest on the arrear family pension shall be decided at the time of final disposal of the writ petition. Full stop. The final decision in the writ petition, final decision, এইভাবে লিখুন, the disposal of this, the final disposal of this writ petition shall take place only after the subject appeal
is finally decided.
Subject appeal is finally disposed of. ঠিক আছে? Paragraph. However, in the event of any default of any direction of this court, in the event of any default of any interim direction of this court mentioned in this order, comma, the petitioner shall be at liberty to mention this writ petition upon notice to the respondents.
But since the case of the state is that the petitioner is not cooperating, she may be ready to cooperate so that the petition case.
If he does not
ask them to be cooperative.
If
whatever you wanted, you have given. Who are you?
Well, please,
unfortunate.
Please. If the petitioner does not cooperate, he will communicate to the petitioner by a letter. It will be delayed. How does it matter to you?
I very humbly ask my friend, is there any allegation against me that I did not cooperate?
Mr. Ali is a much junior.
No.
Stated
With respect,
case of the state.
Chal. All right. কি বললাম?
However, in the event of any default of any interim direction of this court mentioned in this order,
Any default
of any interim direction
of this court on the part of any of the authorities.
One of the parties to act upon my lord, server copy of this application.
Not required to be written. Let them not act and then you mention, your junior will mention. I will take care of.
My lord, kindly pardon me, my lord. চোরের বাড়ি নেমন্তন্ন হাত না ধুয়ে।
All right. কি বললাম?
However, in the event of any default of any interim direction of this court on the part of any of the authorities mentioned in this order, comma, the petitioner shall be at liberty to mention this writ petition upon notice to the respondents.
Bas.
All parties to act on server copy of this.
They will, sir. Don't worry. Please don't worry.
All right.
Only hard truth is that one of the husband of the deceased husband is a member of our family once upon a time.
Member of?
Family of the state, once upon a time.
Chalo.
Why my apprehension? 4 times I have won the case, this DA matter. 4 times in this court. Now it is in Supreme Court. 8 years.
চল আসবে না
Liberty to mention.
ওইটাই তো না, হ্যাঁ, আর আসবে না যতক্ষণে অ্যাপিল ডিসাইডেড হচ্ছে।
My lordship will kindly pardon me, my lord, if I have made my any personal, my lord, question.
I'm coming within 10 minutes. Very well, I cut down 7 minutes.
Yes, I'm coming.
I'm for the respondent number 1.
And for the petitioner, Lordship.
The respondent state in this matter.
Yes.
Is that matter, my lordship, heard last time?
Yes, when there was a direction, there was an order passed by Honorable Justice Amrita Sinha, which is correlated to that, and Lordship directed to submit a copy of that order. It was passed on that date, Lordship. But
কি order?
order was not yet uploaded by the time the matter was called, Lordship.
কি order এটা?
এই অর্ডারটা প্রডিউস করবে বলেছিল। এটা স্টেট ইনফরমেশন অফিসার প্রসিডিউর রেলিভেন্ট আমি বলে
ও সাত নম্বর প্যারাটা দেখো। ডাউনলোড করা যাবে? জানি তো, জানি জানি।
Lordship, I have given a
Well,
copy
the
of
paragraph
order.
7, I think, well, lordship, kindly have a look. I think that is what is relevant of Justice Sinha's order. As the state has put forth its stand and has specifically stated and admitted that the seniority rules and the gradation list of the Unified West Bengal Audit and Accounts Officers have not been finalized, and interstate seniority have not been, and the interstate seniority list as on 1st of March 2001 remains undisturbed. Accordingly, there is no requirement of furnishing any further information to the private respondent as per the order passed by the West Bengal Information Commission. Now, what my learned friend possibly wants to show that the seniority rules and gradation list of the Unified West Bengal Audit Accounts Officers have not been finalized. And interstate seniority list as on such remains undisturbed. So these are possibly she is trying to harp on. Now this issue is pending before the State Administrative Tribunal.
No. So your stand I am reiterating.
Yes.
So this has not been done. Had this not been done on 16 July, what is the status today?
Well, it remains same. It remains same.
Lordship, it has not been done, and Lordship, promotions, recommendations for promotions are given based on seniority. Now, Lordship, in 2001, this unified cadre did not exist, and admittedly, Lordship, by the state.
No, question is jurisdiction, madam.
Lordship,
where we will go.
Lordship, before the West Bengal State Administrative Tribunal, the issue pending is the non-publication or the of the seniority list as of yet, and
that they have said they have not yet done.
Lordship, that is a separate issue altogether.
Now,
Lordship.
in this writ petition, what is your issue?
Yes, Lordship. The issue
That
in
is
this writ petition is
para
Lordship.
3, page 9. Para 3, page 9.
Let's see.
Yes. Lordship, if I may place the factual matrix a bit before coming to my, that will be easier.
Yes. Do in your own way.
Because the factual matrix is a bit lengthy.
In your own way.
Lordship, prior to
Yes,
2001, Lordship, there were two services of the West Bengal Finance Department. One is West Bengal Audit and Account Services, and the other one was West Bengal Junior Audit and Account Services. These were two separate services.
So, audit and account, junior auditor.
All the criterias, promotions, everything was different. Examination procedures and everything was different, Lordship. Now, In 2001, Lordship, just 1 minute, Lordship, to 1990, the petitioners are mostly from the 1999 batch of the West Bengal Audit and Account Services, the Senior Audit and Account Services, Lordship, for ease. Now, in 2001, Lordship, these two services were merged. And Lordship, in 2009, these services were antedated to 1981. Now, Lordship, challenging that order of antedating, an application was filed before the West Bengal State Administrative Tribunal. After hearing of the matter, Lordship, the West Bengal State Administrative Tribunal dismissed the original application, stating that it is the discretion of the court to antedate service and all. But Lordship, there was explicit direction that within 1 year's time, the state will have to prepare the seniority list of the unified cadre. Now, challenging that order of dismissal, one WPST was filed before this honorable court, which was pending for 10 years. Hearing was pending. No order of, no interim order of stay, nothing. No promotions were granted. Everyone stayed in their own position, no problem. Now, Lordship, in 2023, this matter was withdrawn without any liberty on a verbal assurance by the state respondents that the seniority lists will be published. Because of the pendency of the matter, the seniority list cannot be published. So, this matter was withdrawn. On good faith, without any liberty, that was the difficulty. Now, as soon as the matter was withdrawn in 2023, Lordship, in 2024, promotions were started to given, absolutely without any rules, any laws, nothing, absolutely arbitrarily, Lordship. Now, challenging those promotions within the intra-departmental promotions, Lordship, the fresh writ petition was, a fresh original application before the state administrative was filed. Now, that is pending hearing. And it's been contested, where the state submitted that we have the seniority list prepared, could not file the same. In the meantime, we had filed an RTI application. That RTI
in the meantime, this order yesterday, this order came.
This order was passed, Lordship.
So they stand still till date, no list is prepared.
But in the State Administrative Tribunal, they said we have prepared it, everything is there, and they're delayed.
That you place this order before the State Tribunal.
Lordship, that is a separate thing. Now, Lordship, in the meantime, the Union Public Commission, it's a order of the Union of India, Lordship, they published a notification for promotion of all the departments of the state government to the rank of IAS officers, Lordship. Now, we made a representation before the UPSC stating that since there is no seniority list as of finalized, and one of the criteria specified in the notification is seniority, so only for the finance department, there cannot be any such recommendations made. A joint petition was made, no reply was filed. But Lordship, UPSC made one representation to the Principal Secretary of the state, asking from him the present conditions, everything, any matter is pending. We do not know what reply has been given to that, but we see that the final recommendations is passed. We filed
by UPSC
in relation to other department as well as the finance department. Now, Lordship, we filed this writ petition. After filing of this writ petition, Lordship, we received this one communication on the 4th June of 2025 from the Union Secretary. This is UPSC, Union Public Service Commission. We received this letter, they stating that your complaint is under consideration, but the recommendations, final recommendation is already has been published. It is under, we have annexed the copy. After filing of the writ petition, we have received this is under consideration. If I may place a copy, but Lordship, this is a copy. I just have a scanned copy. If I may just produce it, Lordship.
That's all right.
I can just.
Let me see the first. Yes. Let me see. Then why you are saying that she has to apply before the state tribunal?
Because of, kindly have a look to paragraph 3 at page 9.
No, kindly. Let's see first. What is your challenge? Let's see the prayer.
Yes, Lordship.
First, you have to overcome this jurisdictional issue.
Lordship, I do not have any grievance against the state as of now. It's a performer respondent.
It's the performer respondent. Page 16 is the prayer.
Yes, Lordship. Page 16 is the prayer.
16.
Yes, Lordship. Page
16.
Read on.
A writ of and/or in the nature of mandamus do issue commanding the respondent authorities concerned, each one of them, their men, agents, servants, subordinates, and assignees, to not give effect to and/or accept the recommendations from the officers of the Department of Finance, Government of West Bengal in terms of notification being such and such dated 3/5/2024. till
Show me that where is 3.5?
Lordship, I will. Kindly a moment, Lordship.
Page.
It's page 144, Lordship.
P8,
8,
144.
page 144, Lordship.
Let me see.
This was the
This is a state notification.
state notification, Lordship. But this is arising out of a notification of the Union, Lordship. I have mentioned that also, Lordship.
No.
That's an
Wait. So this is a state notification.
Lordship.
This will squarely go before the sack.
Lordship.
Next prayer B.
Yes, Lordship. Written in the nature of mandamus do issue commanding the respondent authorities concerned, each of them, their men, agents, servants, subordinates, and assignees to forthwith cancel the appointment of the merged officers of the West Bengal Audit and Account Services already made from the Department of Finance, Government of West Bengal, following the notification memo number such and such and GOI DOPT notification.
So whatever in terms of 3rd May 2024, you have to place it before the tribunal.
Lordship. But Lordship, this is in terms of the Government of India notification, that is 17/3/2025.
But you have not challenged the Government of India notification.
Lordship, I have also, in the second prayer is that only, Lordship.
Show me.
That is the prayer, Lordship, to not give any appointment in terms of this notification, Lordship. To not make any appointment.
Who shall give appointment?
Lordship, the appointment has to be given by the UPSC with DOPT, Lordship. UPSC DOPT, Lordship, because this is a promotion from the rank of, these are West Bengal Civil Services officers. They are being promoted as IAS officers on the basis of the recommendations by the state, but the appointment are by the Union Public Service Commission, Lordship. Recommendations are from the Union Public.
See the letter which my landed printed process. Just have a look.
You're for?
I am for the UPSC. Respondent number 1.
For?
Union of India.
Kindly see the letter of UPSC.
Yes. Read on.
I am directed to refer to a letter.
Refer to your notice dated 13/3/25 on behalf of Sri Himadir Day and others including therewith to representation dated 22/12/24 and 15/2/25 regarding the non-publication of the Gettysburg list following the merger of the West Bengal Audit and Account Services, and to say that in accordance with the section 4 of the IAS appointment by selection regulation 1997, the responsibility of initiating proposals for selection to the non-SCS officers to the IAS cadre lies with the state government. The preparation of senior list and eligible list fall entirely within the domain of the state government. The commission role commences only upon receipt of such proposal from the state government. Unless the state government sent us to us, we cannot do anything.
Lordship, kindly comes to P11, Lordship, that is in the volume 2, page 158, Lordship. Now this is page 158, Lordship, that is in the volume 2, Lordship.
158.
158, Lordship.
January.
Lordship, this is 17 January 2025, Lordship. This is a notification by the Ministry of Public. This is a DOPT notification issued to the government, Chief Secretary, Government of West Bengal. I am directed to refer to the State Government of West Bengal, letter number such and such, dated 17/1/25 on subject cited above, and to request the State Government to kindly confirm whether there have been any adverse developments, that is court cases filed, order issued by any
Madam, think of the process now. State of West Bengal has to provide the names.
Lordship.
Seniority list has not been prepared.
Lordship.
Let us look at the issue very simply, with a simple eye. Union of India issued a notice, basically seeking names from state government.
State government.
State government will have to furnish names. State government has not yet furnished, not yet settled the seniority list. So your grievance is there.
Lordship.
That unless the seniority list is settled, state government should not send the list.
Sure.
That's your grievance, man. Now, how union will involve?
Lordship, I am only saying not to consider the recommendations. My application before the West Bengal
No, union has no role to play.
No, only to
Union
not
of
consider
India,
the
union government has no role to play.
Lordship, their notification states that there is a necessity of the seniority. Now
Right.
names have been already.
You call for Union of India calls for, let's say, 50 candidates
Lordship.
from West Bengal cadre.
Lordship.
Right?
Lordship.
Now, which 50 will go? That seniority list is not published.
Absolutely.
Correct?
Lordship.
There is your grievance.
No, absolutely, Lordship.
So how the Union India is responsible?
They have accepted those notifications, Lordship, despite we have made them representations only on the basis that my representations were not
your
considered.
representation? What is your representation
To
before
not-
Union of India?
Lordship, kindly, my representation was that this matter is pending. There is no seniority list. Kindly do not consider. Only to that extent.
You have to go before the service tribunal against the state of West Bengal. You seek an order of injunction till your seniority list is not published.
Yes, that's it.
That is
The issue is pending at before the lunch.
So consider the
Yes,
attempt being made. A junior member.
I appreciate.
Absolutely.
Lordship, the Union of India has acknowledged and they're saying that my representations
Yes,
are under consideration.
representation will not give you a cause of action.
No, Lordship, they are saying it is under consideration.
Yes, let them do.
Lordship, if it is under consideration, then how can they give the final recommendations? Lordship, kindly
Who can give final recommendation?
recommendations, Lordship, kindly sees the DOPT notification, that is page 262. The recommendations have already been published, Lordship. That is where 262. That is when my cause of action has arisen, Lordship. That is 7.
Final recommendation with the candidate's name.
Yes, Lordship, with candidate's name. That is 17th March 2025. Now,
Then you have to approach the CAT.
Lordship, I cannot, Lordship, because I am still not a, I am a state government employee, Lordship. My jurisdiction is limited before the Central Administrative Tribunal, Lordship.
So how your right is affected?
Lordship, I am one of the eligible candidates. There is no seniority list. If this name has been accepted, now, Lordship, this 17th March 2025, the recommendation has been already accepted despite all of this. I do not have a forum to go and challenge this because this name has already been accepted by the DOPT, Lordship. Despite the fact that there is no seniority, and it is only that Anindya Bhattacharya, the last name, Lordship. This name has been accepted, Lordship. That is the only grievance that I have. That this name has already, this is when I have filed, this is the reason my cause of action has arisen, not because of the representations, Lordship. I have not challenged, I have not come before this court until and I was making the representations and recommendations were not made. But Lordship, 17th March 2025 gave me my cause of action, Lordship.
So 17th March, if gives you a cause of action,
Lordship.
right?
Lordship.
Then immediately you should have applied before the service tribunal.
Lordship.
That this has come pursuant to the recommendation made by state. State has not yet prepared the seniority list. Grant an injunction on state.
Lordship, kindly looks at the last order passed by the State Administrative Tribunal. This point was raised. Now, on that point, the state submitted that my seniority list is finalized. And Lordship, on this has been the submission of the state since February. Even on the last occasion, it was submitted and finally it was recorded by the...
Second point is, even if that be so, Then why will you not apply before the Central Administrative Tribunal?
Lordship, I do not have a locus to file anything before because I am not a central government employee.
If you don't have any locus, oh, you are not central
I am not
government
a central,
employee.
I am a state government employee. All my cause of action lies before the West Bengal State Administrator. There I have espoused all of my cause. But with the acceptance of this name, Lordship, I cannot challenge this notification before any other forum, Lordship. And it is an admitted position, Lordship, that they are considering my representations. That is their stance only. As late as on 4th June 2025, Lordship, after filing of this writ petition. But the names have already been, they have already finalized the recommendations and these are already on probation, Lordship. I do not have a forum, Lordship.
Yes, what do you say on page 262?
Well, I am not the DOPT. I am only for one, not DOPT. DOPT is a party here. That is respondent number 2. Let them come, let them clarify their position.
You serve them?
Lordship, I have already served. I will serve again, Lordship. I have already served,
Who
Lordship. The
appears for
affidavit
them?
of service
Respondent number 1, Union Public Service Commission.
That you are appearing?
Yes.
And for respondent number?
2, Lordship.
Who
DOPT
appears?
is respondent.
2 is for DOPT.
DOPT, Lordship.
Who appears?
I think no one is appearing.
Calcutta is a party, Union of
I have
India.
served copies, affidavit of service, notice of upgradation, both served, Lordship.
That is why on the first day I mentioned, my lord, there is a mistake, my lord. In Union of India service through the Secretary DOPT, but he made Union of India service through the Secretary UPSC.
Public Service Commission.
UPSC is a separate constitutional body, separate entity. That is why on the first date I mentioned before, lordship.
Union of India through
the Secretary Union Public Service Commission. How it is possible, I don't know, my lord.
But it's autonomous body.
It's autonomous constitutional body. It never. The learned friend has made a mistake.
You have not made this party?
Lordship, I have made the DOPT also a party. DOPT has already been served also, Lordship.
Where is DOPT party?
Lordship, you respond number 2, Lordship.
Yes, the respondent number.
Ministry of Department of Personnel
Training.
Training.
Yes, Lordship. Government of India. DOPT is a party I have served, Lordship.
Respondent number 2.
Lordship.
Yes, respondent number 2 is a party.
But I am not for respondent.
Are you may not.
Yes, my lord. He is a party.
You may not appear.
Union Public Service question. Well, he represents. Let there be the little correction in the cost title that will help my learned
That is why on the first date I mentioned, my lord.
He represents my Union Public Service Commission, and my lord, really, my lord, the Union of India Secretary Department of Personnel and Training.
Yes, he is
That is a mistake.
also.
Yes.
That is a mistake.
So
serve on the Deputy Solicitor General.
But unless my lord, it is corrected, my lord.
What correction? Respondent number 2?
Yes.
Ashu.
Lordship, if a limited stay may be granted, Lord.
No, I don't know anything. And that's a letter of March.
Lordship.
That's a letter of March, madam. You're doing well. She's pursuing very well.
yes, that is true. But then, my lord, the seniority issue.
I am passing any order today, except to serve upon the Deputy Solicitor, learned Deputy Solicitor General, who shall represent respondent number 2.
Only if a short date may be fixed, so that, Lordship, that much. Because I'm not praying any seniority here, Lord.
Mr. Trivedi, I think.
Yes.
Mr. Dheeraj.
Let him come.
Ashu. The writ petitioners have challenged the steps taken by the respondent number 2 through its notification dated March 17, 2025, Annexure P14 at page 262. MS
Debannita Pramanik, Lordship.
Debannita Pramanik, learned advocate, appearing for the petitioner, placed an order dated
ঠিকই বলেছে, he is right.
July 16, 2025, passed by a coordinate bench in WPA 4378 of 2025 and submits that in that writ petition, the state has taken a specific stand.
ওইটা কিন্তু অমিত সিনহা অর্ডারে বলেছেন না, কে করে ফাইনালাইজ করে না কিছু করে না।
That the seniority list that the preparation of the seniority list and gradation list under the seniority rules of the Unified West Bengal Audit and Accounts Officers have not yet been finalized and is at the deliberation stage. The inter se seniority as on March 1, 2001 is not being disturbed. Poster. Mr. Shopon Dotto, senior advocate and additional government pleader, appears for respondent number 3.
It is pro forma responded. No relief has been claimed. Pro forma.
Respondent number 3. Full stop. Mr.
Arun Kanti Chattopadhyay.
Arun Kanti Chattopadhyay, learned advocate, appears for respondent number 1. Paragraph. Since none appears for respondent number 2, despite notice. Where is your affidavit of service?
It is filed on the last day, Lordship.
Full stop. Mr. Dhiraj Trivedi, learned senior advocate and the Deputy Solicitor General of India, is requested to appear in the matter, to hold the brief, to assist this court henceforth in the matter. Full stop. The learned advocate on record for the petitioner shall serve a copy of the writ petition, complete set of writ petition, along with a copy of today's order upon the learned Deputy Solicitor General to enable him to take instruction on the issue. Full stop. Instruction on the issue and to make necessary submissions before this court on the next day. The writ petition shall appear under the heading কিসে আছে?
Motion top.
Motion top. On আজকে কত?
23rd. After 7 days.
July 30?
Lordship.
July 30, 2025. Full stop. আচ্ছা এখানে আরেকটা লিখুন, ওই কি বলেছি নানা পিএস এর পর না ওই পড়ুন তার আগেরটা তার আগে দেবান্বিতা প্রামাণিক, যেটা বললাম। ওখানে আরেকটা পরে রাইডার করুন, রাইডার করে ওখানে ঢোকাবেন। হ্যাঁ, she further has placed a communication dated June 4, 2024, issued by the Undersecretary bracket AIS to the learned advocate and to whom?
Lordship, to the advocate who had made representations on behalf of the petitioners, Lordship.
To the learned advocate through whom representations were made.
The legal notice is served by the learned advocate.
হ্যাঁ,
Legal notices is served by this learned advocate.
ঠিক আছে, full stop. Which shows that the central union authority has taken a stand that the commission's role commences only upon receipt of proposal from the state government. Full stop. The preparation of seniority list and eligibility list fall entirely within the domain of the state government. Full stop. A copy of the said communication is taken on record. Full stop. এটা ফেরত দিন। এই আসো, চল।
Or I am assisted by Mr. Dipankar Das.
Give the name. Give the name. আচ্ছা, লিখুন। এটা কোথায় হবে আমি বলে দিচ্ছি, লিখুন। Mr. Dotto has taken the point of maintainability of this writ petition
In view of section 15 of the Administrative Tribunals Act. Very well, maintainable.
comma, that this writ petition should lie before the state administrative tribunal. State administrative tribunal, jurisdictional state administrative tribunal. Full stop. The point of this point of maintainability shall be heard first on the next day. এটাকে আপনি ঢুকিয়ে দিন, ওই মিস্টার দত্ত অ্যাপিয়ার করছেন বলেছি, তারপরেতে লিখে দেবেন।
Admittedly, the matter is issues pending adjudicated before the tribunal.
To come on that day, it
Yes,
will be
yes.
heard first.
Yes.
It will be heard first. Thank you. Thank you. Life করে দিন।
My lord, I am appearing for the petitioner in the first matter.
My lord, I appear for the alleged contemnants.
Where, which one?
All are same. 1, 2, 3, 4. There are 4 matters arising out of one judgment and order.
My lord, I am appearing, my lord, for the petitioner.
Yes, sir.
My lord, kindly to see the order. 13 June 2022 order, page 23.
My lord, may I file, there was a direction for filing an affidavit in
Let me
opposition.
see what order is
Yes.
Mr. Bandyopadhyay is referring to.
Yes.
13?
13 June 2022.
13 June.
Page, my lord, 23.
Oh, of the contempt application. Then
Contempt
this-
application, my lord, contempt application. Lordship, you got it?
Yeah, 1 second, sir.
Yes.
Application ta din. Contempt. Just wait.
Yes, yes, my lord.
Service sector din. Yes, which page, sir?
My lord, page 23, my lord.
All. (23). Yes, sir.
Can I read the whole order so that the
Yes,
entire
yes,
facts will be remembered?
Absolutely.
Students of the
You do in your own way.
My lord, students of the West Bengal National University of Juridical Sciences are before us. They are agreed by a judgment and order dated 1st March 2019, passed by a learned single judge of this court dismissing their writ application. In or about 2012, the West Bengal National University of Juridical Science decided to start online courses in various subjects. My lord, got it?
Yes, yes.
For proper administration of this course, it took the assistance of a facilitator, that is IPDES, the second respondent in the appeal. IPDES and the university made an
Wait, just wait. What is the role of a facilitator? What do
facilitator? There is an agreement between the NUJs and the IPDES. They will, that is their agreement. They will provide the service so that the online course can continue. We have nothing to do with the IPDES, but IPDES was a party. Numerous students enrolled themselves for this course. It went on smoothly till September 2018. It appears from the submission of Mr. Anil Kumar Gupta, learned advocate appearing for the University Grant Commission, that this online course did not have the approval of the commission. The executive committee of the university stopped the course by a decision made on 29 September 2018. In the affidavit filed on behalf of the University Grant Commission, it has stated in paragraph 5C thereof that online course had not been approved by it. Mr. Anil Kumar Gupta cited two unreported decisions of our court. The first was so I'm not relevant. Then the facts of this case, your lordships have distinguished this fact. Then second, and then now kindly come to skip over 2 paragraphs. Then in that case, admission to an institute was granted on the basis of a qualification by distant education, which was not recognized by the University Grants Commission as sufficient for admission. On those facts, this court had declared the admission of the constituent invalid. West Bengal National University of Judicial Science is a premier institute at a national level for conduct of legal studies. The degree and diplomas and other qualifications granted by it are of high value and obviously recognized by the University Grants Commission. However, it appears that the online mode of study may not have been expressly approved by the commissions, under the impression that it also had the necessary approval to run online course and grant degrees and diploma, etc. The university had started them from 2012. When a premier institute like the West Bengal National University of Juridical Science announces a particular course, no student would ordinarily go behind the announcement and try to verify whether the University Grant Commission had approved it. The students were most likely to presume that such approval had been obtained from the University Grants Commission. On the basis they enrolled themselves, the courses have been continuing from 2012. The students have not only spent money, but also extended their time and energy in pursuing the courses. In our opinion, at this point of time, it would be most inequitable and unjust to recognize the course, cancel it, and direct refund fees. Since on the representation of the university, the students had undertaken this method of study and thus altered their position, the doctrine of promissory estoppel would prevent the university from calling off this course. It would also prevent the University Grants Commission from recognizing it. In those circumstances, we direct that the students who have already enrolled themselves for the online courses from 2012 and not completed it, it should be allowed to complete course if otherwise entitled to do so. On successful completion of the course, they would be awarded the requisite degree and diploma, etc., by the university deemed to have been issued with the approval of the University Commission. No new enrollment for the online course shall be permitted unless expressly authorized by the University Grants Commission. The subsequent development may be brought to the knowledge of the arbitral tribunal deciding an arbitral dispute arising out of and arranging for implementing the online school between students. This order was, special leave petition was filed against this order. That is, kindly come to page, my lord, page,
Even on 8 of the opposition.
This is 12 December.
8 of the opposition. Their opposition.
12 December 2023.
देखिए opposition देखिए.
This is
Opposition कोता है?
They have not filed.
no, not they have not filed.
Not yet. Yet.
Today was the day that we have to hand over before your lordship.
They have served a copy of us. They have served a copy of
So
us.
just one sentence first. Let us record that they are filing today.
Yes.
Yes.
Ashun. Mr. Kollan Mondopadhyay, Learned Senior Advocate, through virtual mode, appears for the petitioner, along with Mr. Shumon Sengupta, Learned Advocate, appearing physically.
And Mr. Rahul Singh.
Mr. Pratik Dhar, Learned Senior Advocate, appears for
The contempt Vice Chancellor of
how many?
2, 1 and 2.
Both you are appearing.
Yes. It's a
alleged contemners. Full stop. Alleged contemners. Full stop. On the prayer of on the prayer of Mr. Dhar, paragraph. Time to file opposition in the contempt proceeding stands extended till today. Full stop. The affidavit in opposition filed in court today is taken on record. Full stop. Copy has been served. Paragraph. Identically, on the prayer of the Learned Senior Counsel for the petitioner, the affidavit in reply filed today in court is also taken on record. Yes.
Kindly see the order of the Supreme Court.
Page
7.
Yes, sir.
Now, kindly see, we have heard learned counsel for the parties. The court has taken a view. I got it.
Yeah, yes.
The court has taken a view as reflected in the paragraph where it is dealt with the aspect of a premier university NUJS announcing a particular course and students joining the same. This court has worked out the equities to see that such students are not prejudiced. In view of the aforesaid facts and circumstances, we are not inclined to entertain this special leave petition. The special leave petition stand dismissed. Needless to say that the impugned order is certainly not a precedent for other courts. Now, my lord, this is your lordship's orders have been upheld by the Supreme Court and they have dismissed this. Now, your lordships kindly see, my lord, kindly come to paragraph. Kindly come to, my lord, main petition. My lord,
so the direction is just once again, we will see, sir. In those circumstances, we direct that the students who have already enrolled themselves for the online course from 2012 and not completed it should be allowed to complete the course if otherwise entitled to do so. On successful completion of the course, they would be awarded the requisite degree and diploma, etc., by the university deemed to have been issued with the approval of the University Grant Commission. Acha, no new enrollment on the online course shall be permitted unless expressly authorized. Very well. Now, where is the violation?
now, my lord, kindly see, kindly come to paragraph 16.
Yes.
Paragraph 16, kindly see that the same by which that despite the lapse of more than 8 months from the date of common of the same by such acts of contempt inter as follows, not awarding the requisite degree and diploma etc. to the students by the university which will be deemed to have been issued with the approval of the University Grants Commission. They have not done it. Now, we will kindly come to paragraph
paragraph.
But your lordship will find that kindly come to paragraph 11.
Yes.
But first, your lordship kindly come to paragraph 10. Paragraph 10, we have sent about the notice. When despite of the lapse of 8 months from the date of communication of the solemn judgment and order dated 13th June 2022 upon contemners, the contemners did not take any step whatsoever to award the diploma to the applicant and to comply with the direction enshrined in the solemn judgment dated 13th June 2022. The applicant, through his learned advocate, sent a notice of the content upon the content 16 May, thereby calling upon the contemner to comply with the direction and so and so. Well, this is the part is the contempt, they have not done it. Your lordships kindly come to paragraph, kindly come to page, kindly come to prayer portion, page, or the cause title portion your lordships will find, page 4. Page 3, kindly come to page 3. Page 3. By Professor Dr. Nirmal Kanti Chakraborty, Vice Chancellor of the West Bengal National University of Juridical Sciences, Mr. Raja Chakraborty, Registered the West Bengal National Sciences, Dr. Anirban Mujumdar, the Director School of Distance and Mass Education, West Bengal, in the following manner, but not allowing the students who have already enrolled themselves for the online course from 2012 to complete the course by not scheduling the final examination of the student. Then too, by not awarding the requisite degree and diploma to the students by the university which will be deemed to have been issued. Then, my lord, kindly come to page 19. I have said about the issuance of rule.
That's the all right.
That's it. Now, my lord, kindly come to their affidavit in opposition.
That's right. What is their stand?
Fine. And my lord, kindly come to this. Kindly come to paragraph 5.
Yes.
With reference to the statement made in paragraph 10 to 12 and 16, I deny and dispute each and every connection and state there is no deliberate and willful violation of the judgment order. State the university distributed notice on 19th October in the website of the university inviting applicants who are willing to continue and complete their course to apply. Well, this was not required to be done. They have to allow.
One second. Just 1 second.
Yes.
It is stated that university had issued a notice dated 19th October 2022 in the website of the university inviting applications.
We are willing
to continue and complete the
course to apply. The applicant did not apply to complete the course. It is stated that petitioner applicant is very well aware of the fact that the online courses were not organized exclusively by the university but in partnership. But see how they are shifting their stand. See, but in a partnership with a private entity known as IPDES, applicants changed their name to Law Chico, but the same person conducting the said company as well as maintain the same official address. It is also an admitted fact the university had entered into a memorandum of understanding with the IPDES for conducting of the online courses. In the present scenario, IPDES in consultation with the university would conduct the examination. University alone cannot conduct the course, but equal participation of IPDES is a requirement for completing the course as well as awarding the degree as well as this program. The non-cooperation by the IPDES brought to a stalemate situation, and for this said reason, IPDES is a necessary party in the present. My lord, kindly see that page 4.
Non-cooperation you have started?
Yes.
Oh, yes, I got it. Yes, sir. Yes, Mr. Bandyopadhyay.
The non-cooperation by the IPDES brought to a stalemate situation, and for the IPDES is a necessary party in the present context. Honorable direct the applicant to impede officials of IPDES as party to the present content application for proper adjudication of the matter. It is pertinent so and so present answering alleged contempts are neither delivered. Remember what my submission is this. I do not know any IPDES or anybody. I know only NUJs. Now, how the NUJs will do, if there is an internal failure by them, that does not purge them from the committing contempt. They have to bring it, they have to make the arrangement. That was the directions of your Lordship's court. Just I just take your Lordship's order, kindly just excuse me, my lord. Kindly take, my lord, again, kindly take the order. That will be very clear, directions part. My lord, your Lordship will see at page 27, your Lordship.
In those circumstances.
In those circumstances, we direct that the students who have already enrolled themselves for the online course from 2012 and not completed should be allowed to complete the course of, if otherwise entitled to do so. On successful completion of this, they would be awarded by the requisite degree and diploma by the university deemed to have been issued with the approval of the University Grant Commission. Whole direction was upon the university. Now they cannot suck their responsibility by saying, no, this IPDES is not cooperating with us.
They cannot shrug off that there is a third party involvement.
Yes. By showing that they cannot do it. There was a clear case of contempt, Miller. Kindly, Miller, let me be very honest to your lords. Very honest. I don't have any intention to punish anybody. But the order has to be carried out by them. I have no intent, I don't enjoy any sadistic pleasure to send them to jail. No, I don't. But what I want that this order should be carried out by them. And they went to Supreme Court. Supreme Court has dismissed. Supreme Court has rather said the equity has ordered this one is.
Not only that, yes.
That the court has worked out the equities to see that such students are not prejudiced.
Sir, equity, no equity, the order has been crystallized. Order is crystallized, direction is crystallized. Now, let us hear the university.
Yes.
Rather the contentness, alleged contentness.
Yes.
Because now I am not university, I am the alleged.
Absolutely.
Yes, I understand. Before I begin on anything on this case, There is a zero intention that a vice chancellor would be at all thinking that an order of the court would not be complied with. But that's
Ajay, just 1 second to both of you. Has rule been issued?
no.
No.
Now, kindly straightway come to the order part. But one factual corrections. It was not the university went before the Honorable Supreme Court, because we also want it so that the students do not suffer. So that was also my submission. True, for online, it was the UGC. Their entire submission was, no, you cannot do it. You need my permissions, etc. The UGC went before the Honorable Supreme Court, and before the Honorable Supreme Court, we took a very soft stand. So as far as university is concerned, from the day one, we had absolutely no intention not to have any equity if they are entitled to. But what is the difficulty that we are today with? And there is a solution also, subject to if Mr. Bandyopadhyay and if your lordships feel at all, there is a clear cut.
Then you suggest the solution in presence of Mr. Bandyopadhyay. Let him
Solution.
hear it.
Yes.
Mr. Bandyopadhyay.
Yes, Malik. Yes.
He is making some submission for
Yes.
your client's consideration.
Yes.
Lordship may kindly come to page 27.
27 of what?
27 of what?
Of the contempt application, the judgment and order, the main portion, the direction.
In those circumstances.
Yes, in those. Now, in that paragraph, there are 4 points. Number 1, who have already enrolled themselves. Kindly mark, I don't have the data for which on website I gave a notice. Kindly give me the data. I can't award and degree to each and everyone. I need to have the data. There is a notice I published on the website. Neither the applicant nor the others who are not even parties there. I don't mind whether somebody was a party, not a party. All I say, the mechanism by which I was working, I have the memorandum and everything there. I did not have any data. So I put a website. Lordship, have a look at that website and then
I take your submission.
Yes.
We rather,
Yes.
Sorry. We
Why?
take your submission.
For the purpose of other 3. This is number 1, whoever enrolled. It's not for anybody other than enrolled, number 1. Number 2 is, and not completed it, it should be allowed to complete. So therefore, first is enrolled, must be allowed to complete it. Third, the courses, if otherwise entitled to do so, I'm not stressing on that, because that is basically attendance and others. No difficulty for that. On successful completions, that means there has to be an examination. The prayer in the contempt application is give me degree. In the context of page 9 of my opposition, I don't have any difficulty to give a degree the moment I see that this gentleman is enrolled and these ABCDs are fulfilled, for which I can again give a notice and he can come. Lordship, may kindly come to page 9 of my opposition. Because I myself, my lord, said to the VC, whatever happened, that was some mess up. So let us put an end to it. Kindly have a look at my 9. Notice in accordance of the decision of the Honorable High Court, Calcutta.
9.
Yes, page 9.
Stamp paper document.
9 is
From your opposition?
Yes, for my opposition.
9 is a stamp paper.
No. Sorry?
R2, my lord, R2.
8. All right, 8.
Page number
8.
আমার এখানে 9 হয়ে গেল।
In my copy also 9.
Oh. So I think
is this the one?
Only this is the one.
All right.
That is 8.
R2 8.
I don't know. R2. Let us go with R2.
All
yes. In accordance with of the decision such and High Court dated such and such and directions of 84th Executive Council held on such and such, all the degree, certificate, diploma courses suspended, notice dated such and such will be resumed and completed. Now, the students enrolled in these courses are requested to register their details for completion of the course in the link below provided within 30-10-22. The question is why? Because kindly come to some of the at least 2 pages, page 13 of the same opposition. And I pleader was a party there in the writ proceedings. But I don't want to bank on that. All I say, either get hold of the I pleaders or you come to me. Give me your documents that you are enrolled. And then I will hold the examinations. You pass, I will give the degree. But instead of that, in the contempt applications, Lordship has seen that their allegation is, I have not granted a degree.
So what is your solution?
My solution is, I can put up another notice saying, whoever got themselves enrolled, please provide details. I can fix up a date also. Whatever documents, whatever evidence, not evidence, I mean, whatever requirements are there, provided to the university. There may be a window for that, for timing. Thereafter, for whom it is not completed, we will take the classes, because now we can't do it online. We can take the classes, take responsibility, complete it. Then we hold an examinations and we will grant the certificate. But without all those things, the conditions in the very directions, I am not taking any of the vague directions. For an example, enrollment has to be there. I have to have some documents, because the mechanism was that entirety was with the I pleader. They realized the mistake. We don't have anything. That was the difficulty.
But thing is, Mr. Dhar, firstly, when this matter was taken up and heard considerably, these points were not taken.
These points were taken, and that is the reason the order of the Honorable Division Bench was in this fashion. May I read it?
No, but the order of division bench does not record it.
May I say?
Unless it is there, sir, I am
there.
not going to. Where?
Not,
Show me.
it is there. It is there. In those circumstances, we direct that the students.
No, no, you show me those circumstances involve those you have made submissions.
No, I am not saying that Lordship need to take my circumstances. I am saying the order itself, it is not an order of grant certificate. It's an order of subject to.
Very well, very well. Question is, these points were, what you are urging today,
yes,
was never before the coordinate bench.
No, because I did not take it. I wanted to end of it. I was
All
with
right,
the students.
One.
Yes.
So whatever reason, you have not taken it.
Yes.
Maybe bona fide, but not taken it. When the matter traveled before the Honorable Supreme Court, neither the
Not by-
SLP carrier
Yes.
took it.
But
The party preferred SLP did not take it.
my point, I'm not. My point, Lordship is referring.
Order does not reflect anything.
No, it is crystallized. I want to stand on this order itself.
So now, if you stand on the order itself.
Yes, it requires an enrollment.
All right.
It doesn't say that the.
After all, whatever third party.
Yes.
He has acted as an agent.
And who was the party? And who was the party in the proceedings?
But he had acted as an agent.
Correct.
Right?
Correct.
You being the principal.
Yes.
Holding the examination.
Yes.
You don't have anything.
That anything is my endeavor.
No, Mr. Dhar.
Yes.
Kindly visualize. Third party agent.
Yes.
Very well. He is acting on your behalf by floating the advertisement and by doing everything online.
Not that only. Kindly have a look at page.
No. What is
page,
really?
Kindly have a look at page 13 once thereafter. Kindly look page 13. Lordship will understand. Otherwise, paragraph Roman 7. They want the degrees. We are ready and willing, but there has to be an examination. There has to be enrollment.
Roman 7.
Roman 7.
Yes.
That was the mechanism. I pleader would be responsible for all aspects of academic delivery and management, subject to the university rules and procedure.
This is the contract between you and that third party.
That's the reason I'm not saying that I'm saying I'm responsible.
No, but what the plea you are taking, I mean, your client is taking today.
I don't have the data. Who actually?
Yes,
that's the thing.
That sounds to be unbelievable.
But then what will happen? Anyone comes and says, I have to grant a degree.
But no, but equally it is unbelievable, little unbelievable.
No, this is the situation.
Because the principal is holding an examination.
That has happened. Well, I take I take response.
The agent is acting on his behalf, and the principal will have not the data.
Well, this
ultimately, the entire examination fees have gone to the credit of the account of your client.
No.
I mean the university.
I believe it is 70% gone to the I players only.
Very well. 30% has gone to you.
Not even entirety.
Very well. 70, 30, that is an understanding between you and your agent.
Yes, I'm not on that.
Right?
Yes.
It's you and your agent.
Correct.
But what will happen to the future of the students?
May I say this? I have absolutely no difficulty to hold an examinations for those that I know who are they. That is the difficulty. Now,
Mr. Bandyopadhyay.
Yes, my lord.
What is your what would be your practical solution from you?
Brother, this is very.
You are the most veteran and experienced who is now involved in this matter.
No, while appearing as in for contemners, Mr. Bandyopadhyay is most veteran while appearing in the toughest matters in the
what
for the
should be the
contempt.
solution?
I am coming to the solution, but this is very unfortunate that an institution like NUGS will act in this fashion. Very unfortunate. But we expect from the NUGS a high standard
and morality.
This is they have deviated.
What
may I submit? What Mr. Dhar has said, your lordships can record that this on the basis of his saying, because your lordships cannot change the main order.
I cannot. None of us.
None. Therefore, that they want to do it in this way. This notice in the website is not sufficient, because my clients may know now the website will be checked. Then they also give one this types of notice like an advertisement any English national English newspaper.
That if it is from your suggestion, if it is from your experience,
I can go for that. No difficulty.
He will undertake.
Yes.
No question of change. No question of changing the order. He will undertake.
Correct.
He will publish in one English national newspaper.
And
right?
also in website.
Once in a popularly circulated Hindi newspaper.
Right.
Once in a popularly circulated Bengali newspaper.
Yes.
And once in a English popularly circulated in the city.
Yes.
4 publications they have to undertake.
Yes. Then
you suggest your solution. Let us all first hear the solutions from an experienced person.
Along with the website, this notice should be published in the 4 newspapers which your lordships have suggested. Now they let them give a date.
We can give a window also. That's some date, not a small. Maybe 7 days.
Those are formalities.
Yes. Things can be sorted out.
Yes.
Yes,
and
the substantive solution.
In fact,
one substantive solution.
If the candidates gives their enrollment, then they have to act on the basis of that. They will not say this is not a correct enrollment. It is not a correct enrollment or.
Here I have a question.
Prudence check we have.
No. These are all difficulties all of you might face. Then in that case, Mr. Bandyopadhyay, let's take one candidate has seen this advertisement. Now, he will have to submit something.
Yes.
Yes.
What he will have to submit before the university?
That he started the course, whatever money paid, some documents, whatever.
Some documents,
Some
any
prudence
nature.
check has to be there. It has to
Some
be reasonable
documents.
prudence.
That the money which has been given to them, whether that will be done also. Sometimes receipt is not there. If their transaction is online or a check, etc., that will be done.
Anything,
Anything.
any bona fide thing to show and come to a conclusion that he was enrolled in the course.
This is a case of enrollment. Now, let's assume that 1 year have been study has been done. Then after it has been stopped.
I have a suggestion. I have a suggestion. In fact, it might.
Yes,
tell
you.
Can I just make one thing, Milord? That it is better give us 5 or 7 days time. Mr. Dhar make a draft one. Let me see that. And
I was weak. I think I can talk to Mr. Bandyopadhyay after I sit with the VC 1, 2, 3.
You come up with a typed written agreed terms. What should be the modalities?
Let Mr. Dhar fix it up. Losses takes it up next week or anytime.
That I cannot assure you because it's a broken division bench.
Whenever both your lordships are convenient, I am saying that is a convenience. Convenient part, not my convenience.
No, because everybody.
That is your lordships. Whenever feel convenient.
Everybody's, Mr. Bandyopadhyay, everybody's convenience.
7 days, give at least 7 days time, then your losses will.
Well, this is the matter. I mean, nothing to do with this little. From the day one, all I wanted so that I lose. And this mess up is somehow is sorted. And that our court intervened and passed this order.
Very good.
This is a contempt proceeding arising from an order dated June 13, 2022, Annexure P1 at page 23 to the contempt application passed by a coordinate bench. Page SLP order ta koto 7. Page Annexure R1 at page 7 to the affidavit in opposition shows that by an order dated December 12, 2023, the Honorable Supreme Court dismissed the special leave petition
by UGC
carried out from the said order dated June 13, 2022. Paragraph. Therefore, the said order of the coordinate bench dated June 13, 2022 has achieved its finality and is crystallized. Post up. Mr. Pratik Dhar, Learned Counsel, appearing for alleged
1 and 2.
Contemner numbers 1 and 2 submits that the alleged contemner numbers 1 and 2 have no intention to violate the direction of the coordinate bench, and they at all material time were and still are ready and willing to comply with the direction and to give effect to the said order of the coordinate bench dated June 13, 2022.
To the actually enrolled candidates, only that part.
He further submits that at the threshold it is required to ascertain who were the actually enrolled candidate in the course, as the enrollment took place in the year
2012.
2012.
12 and onwards.
12 onwards. In this regard, please hear Mr. Bandyopadhyay. In this regard, paragraph, Mr. Pratik Dhar, learned senior advocate, submits that in consultation with his clients, he shall come up with the suggestions with regard to the modalities for complete compliance of the direction of the coordinate bench. Full stop. Paragraph. Accordingly, Mr. Dhar has submitted that he shall draw up the modes and modalities and then shall place the same before this court on the next day. Paragraph. That's all?
Yes, yes.
Yes, yes.
So you
Yes,
sit
yes.
with Mr.
There is,
Bandyopadhyay and
I want, there is, this is not a kind of matter that
so you
as a
guide
lawyer,
them.
Yes.
Modes and modalities and then do it. But for newspaper.
if that situation
No,
comes, if that situation comes,
no, has to be, because you have to publish it in the website.
no, I understand, but Lordship is, I don't know about the financial involvement of the four.
That is, sir, you have to.
I have no difficulty.
That the content, alleged content has to.
It's not my money. It's these decisions, why I said I wanted.
Very well. Leave it on the court. Four has to be.
No, NUGS has enough money. The central government funds.
This is the matter.
We are providing funds to you.
Yes. All right.
Budget clears.
All right.
There is not a single place. There is a complaint, any deficiency of money.
The matter shall appear
And
under the heading.
only you invite the CGI and the two senior judges of the Supreme Court. You never invite us.
Under the heading? কি হেডিং আছে একটু বলুন না। Matter shall appear under the heading content application within bracket assigned. Next date কবে? না তাহলে একটু আগে করো এটাকে। ও আমরা 2-8
Wednesday.
এক মিনিট 6th আমার কি মামলা আছে দেখুন লিস্ট।
Wednesday, second half.
দুটোর সময় আজকে কি নেই তো ভেরি গুড on August 6th?
Yes, yes.
August 6th. 2025, marked at 2 p.m.
You know one thing, that NUJS invites the honorable judges of different high courts to their NUJS campus, only those who will go to the Supreme Court. And that is as per advice of Mr. Pratik Dhar.
As per advice of
Mr. Dhar.
Of course. I myself have never gone there. Because
Thank
I
you.
said every time they are taking my
I was a member of the NUJS committee that state government never has invited me for any meeting or any other thing.
Thank you.
I'll give you a blessing. Grateful to your lords, both of your lords. Grateful.
Thank you. Thank you.
আমাদের লোককে নিয়ে গিয়ে বসিয়ে রেখেছে
ভিতরে রাস্তা আছে কনসিডারেশন করার চেষ্টা করছি আমরা এভিডেন্স আজকে এখন ফাইল করছি না আমরা এখন প্রাইমারি কল্যাণ কাকু অ্যাপিয়ার করবো can be resolved. We will do that. There is no question of saying our favorite right. Everything has been just
Yes.
Your Lordship will see, just recall the order.
Let us read. How can I recall?
There is a direction of evidence.
No, but before that, I think
Let us see.
page 15 is the
Let us see the order.
yes.
You supplementary affidavit?
That was already given last time.
Yes. What to do? আজকে পুলিশ হোয়াটসঅ্যাপ ফিডব্যাক জাস্ট টেক বেটার ওয়ে কিন্তু কিন্তু রেকর্ড করালে আটকে যাবে আমি 7 দিন
Yes, opposition reply.
That was there, but the scope of the order is very limited. If your Lordship permits me, I can show your Lordship in a very short order. The first.
But no, but what happened? The last paragraph, last penultimate one. It is made clear that pendency of this contempt proceeding shall not preclude the alleged contender if it wants to reconsider its reasoned order in the light of the such and such.
Milord, as of today, Milord, I am only
Take the microphone.
Milord, as of today, Milord, I am only praying that 7 days time be given to us. Milord, there would be, Milord, even Mr. Bandopadhyay, Milord, he has yet not been briefed. He will also appear in this matter to further effective assistance of the situation. So, Milord, Milord, there has to be a change in the contemner's details, Milord. Now, the contempt is.
Mr. Sen, are you hearing?
Yes, I have already apprised Mr. Sen before the matter started, Milord. So, Milord, this adjournment, if we are given, Milord, we will try to ensure that the court's order are complied with in a manner that everybody is satisfied. Milord will not record that, Milord. It is just my submission to the court as the officer of the court. But I am just praying for a 7 days time, Milord, so that we can reconcile all the documents. হ্যাঁ এবং আমরা একটু তোমাদের থেকে বাকি ডকুমেন্ট গুলো না আমাদের কাছে সব নেই হ্যাঁ ওই যে ছিল ম্যাকফ্যান আমাদের কাছে কিছুই নেই And Milord, off the record, Milord, we also will be requesting Mr. Sen's advocate on record so that we are supplied with the documents of the appeal, Milord, because we somehow are not been in a position to have any of these documents.
Mr. Sakko Sen, Senior Advocate, appears for the petitioner. Mr.
Nag,
full name,
Orko Kumar Nag.
Orko Kumar Nag, learned advocate, appears for the alleged contemner with Mr. Shuddhadev Adok, learned advocate. The last order dated June 18, 2025 speaks for itself. Full stop. The penultimate paragraph of the said order shows that pendency of this contempt proceeding shall not preclude the alleged contemner to comply with the direction of the court. Paragraph. Today,
comply with the direction of 13th of June.
Compliance of the direction dated June 13, 2023. Full stop. Learned counsel, paragraph. Learned counsel for the respondent, referring to the said observation of the court, submits a praise for few more days' time. Respondent, an advocate for the alleged contemner. Referring to the said observation from the order dated June 18, 2025, submits praise for some more time. Full stop. Accordingly, the matter shall appear under the heading Contempt application within bracket assigned on August 6, 2025. এই আমার কিছু নেই তো বেইজ্জত যেন হতে না হয়
Only thing, my lord, it is expected, since my learned friend is saying they will do something positive, at least to comply with the order.
Sir, what did I record?
Otherwise,
what did I record? He said he cannot make his submission today. As an officer of court, he has informed. What did I record?
I'm only saying this, even then on the next date again, the extension of time is prayed for.
No. So let's see.
So not for compliance, then at least they must come with the ready with the affidavit to contest the matter.
Yes.
That is my understanding.
Either way, it will be.
Yes.
Either way, it will.
Full stop. The petitioner, the time to file affidavit in opposition stands extended till in the meantime.
Oblige. What?
Yes.
হ্যাঁ স্যার আমি সরে যাচ্ছি আপনি
You are feeling exhausted? Take your seat. Take your seat.
After eye operation,
Take your seat. If you want, you can come on the next day also. Take your seat.
এটাই ভালো
হ্যাঁ
পরে কিন্তু কোনো শরীর খারাপ হলে করতে হবে
তা করে দিন করে দিয়ে বলছি
কি বুঝতে পারছি
My suggestion is to take rest. The junior suggestion is to proceed with the matter.
He is ready, my lord, today.
No, no, I don't mind. You take rest.
Ready today.
Sit on the chair. Sit on the chair.
Sorry.
Your health is more important than your health is more important. Your health is more important than your client.
That's why I'm getting faster.
Cataract. Huh? I did also 2 months back.
At a young time.
Because of the polluted vision. You have seen the golden days. So you could sustain the original eye.
In the old golden days, I was born in 1938 when the entire world was preparing for the World War. 39, Second Great War started. 1940, our freedom movement started. 43, Famine of Bengal.
So you have seen those golden days. That's why you could sustain with your original light so long.
Very bad. Then 46, now 47, liberty, independence. But Bengal
41, death of Tagore.
Bengal was divided.
The death of Tagore.
In Bengal,
41.
we have seen the bad days. And we have seen the ration. We have seen the control. We have seen the control of clothing. We have seen the hungry people. Even we have seen at the Nemutono Valley, they used to pick up the wastage. Fallen in the
Famine.
after doing all those things. The heart of my father wait for something. They asked them to come and for them 100 people or 50 people ask us, Harika, to keep them. And we have seen the clear kitchen, not golden days, but gone under bad environments. But we have to sustain because of our
When you were enrolled, sir? 68.
Then of course I was lecturer of law. After that, what up to then and I will speak more.
He is from Calcutta University.
Yes.
Which year?
Passed out.
And many of
Like,
the students,
The graduation I did in the year of
law,
99.
You did not pass.
99. How can I appear on a debate? No, I was calculating the 57 years of practice.
8 years, yes.
Years. I'm now not even born.
I was also not even born.
It was so
Much after.
continuing my food. I don't go restaurant or hotel.
You don't go.
No, I don't take
skill.
hotel. I was sent.
Take these junior one day. Take these juniors one day.
সবাইকে নিয়ে যেতে হবে
Invited them, many occasions, but I am not taken. Even I had been, because I had represented Bengal at UNESCO conference for legal aid. Because Calcutta High Court was the pioneer in starting the legal aid. Calcutta High Court. And I will not say my credit, but I asked Mr. Vajpayee and Justice about this party. এরা তারা করতে হয় না আমি পাড়ায় ঘুরে দেখেছি যে যারা জানে না সরকার জানে না
স্বামী মরে গেছে আর সম্পত্তি পাবে, তারা জানে না স্বামী খরপোশানি করা খরপোশ পাবে প্রত্যেকে সাথে পার্সন।
Yes.
This is also okay. We are not born in golden days. Anyway, HON'BLE. My lord.
Yes, sir.
Different stuff. So first of all, my lord, I saw my document. I have given.
You have given? কোথায় দেখি?
What are you have given?
কোথায়?
At page 16. কপি আছে?
পাচ্ছি না।
আছে, ফাইল করা আছে।
এই একটু দেখুন তো এখানে আছে কিনা, আমি তো পাচ্ছি না।
If not, I can file করা আছে, file করা আছে। If not, I can give our copy.
জুনিয়রকে দেখা।
I can give our copy.
No, you keep it with you, sir. Let your junior search it out.
In short story, I have given my father had done, he has spent his last saving for the move, for those starving people during 1943. Last many years spent. Real kitchen. এটা একটু দিয়ে দিন। পেয়েছেন? হ্যাঁ, এই যে পেস্ট। কপি আছে তো? ফাইল তো করেছি আমরা। শর্ট নোটস
আছে?
May shortly.
Yes, sir.
My land and structure has been acquired on the approach road from our side to second road. Under Act 148,
Requisition and acquisition.
Let's just repeat, my lord. Now, Act 1928. Then what happened, my lord? Under protest, we have returned that particular money, but even 18 reference and case has been started at the Honorable at the Tribunal at the court. King decides to with the judgment. We have come first at the High Court. On certain points, first appeal bench of first court was not being pleased to expert, then it was sent back of the court.
Section 18 court. District court.
Then here shall be announced. And
Then, sir, madam, place the microphone properly.
We are back.
No, the acoustic system is little problematic in this room.
Then, my lord,
Yes.
again we have come before our Honorable High Court in another first appeal. Our first appeal has been pleased to enhance the land value from 18,000 to 25,000 per katha.
Enhance the land value.
Land value from 20,000 to 25,000. 20,000 given by the tribunal second time, 25,000 that the High Court has given. Thereafter, structure value has been also enhanced. Now, on the basis of our government valuers report appointed by us, they recognize government valuer. That is, my lord, annexure annexure 16. Oh, sorry, annexure 12. Just a minute. Page 12. Annexure P1.
Page 12 of
this
content application.
No, our
written notes.
Our notes of argument.
All right.
What short hierarchy? Now it is our case. Now the question, my lord, would be.
So page 12.
12 of the
Page 13, page 12, sorry, 12, starting from 12 of the our written argument.
That what is that? That is the
Valuer's report
valuer's report
engaged by us, engaged by my client.
Engaged by your client.
He's a government valuer. He has been examined in the section 18. He was examined and satisfied, and we still stand on his basis. Now the question.
Let us read the law order from which contempt arose.
Yes.
Show us the order.
Yes.
Which page, sir?
Yes.
Which page?
I'm coming, my lord. My lord, page 66 of 75, 66. That is the 68, sorry, 68. Page 68, my lord. Page 68.
Yes.
Have you got it? First appeal, an instance of the referring claimant was directed against an award dated January 30th, 2002, passed by the Barnet Land Acquisition Tribunal, Howrah, in LMS case number so and so, thereby enhancing the amount of compensation payable to the applicant from rupees 9,000 to rupees 20,000 per kata as regards the portion of land in question. Other consequential benefit, order regarding solicium, interest, and other things, my lord. Then, my lord, when the appeal was heard on November 1 to 8, two questions was raised by the learned counsel for the appellant first. In the same vicinity, in respect of similarity situated land decided in LMS case number so and so, award has been passed on June 6, 2003, giving higher compensation to the claimant therein. Secondly,
sir,
my lord,
straightway come to page 74.
Yes.
Any SLP carried out?
Yes. Paragraph
15.
15.
1-5.
The state is directed to pay the enhanced compensation along with other consequential amount pending to the appellants within a period of 3 months from today.
You have not been paid.
Partly paid.
Why you say partly?
Partly because as per their calculation, they
So
have given.
kindly now, sir. Now kindly come to paragraph 14.
Yes. Taking into consideration all these facts, learned LA Tribunal negated the claim of the applicant for higher compensation as par with the structure standing on holding number 10/3 Hiralal Banerjee Lane. Taking into consideration all other facts and circumstances, the learned LA Tribunal enhanced the claim in respect of structure to rupees 1 lakh, holding that such compensation is far enough for the structure. While disposing the appeal, we are of the view that while assessing the value of structure, the learned LA Tribunal should also have taken consideration the prospect of development around the appellant's land in future. Very important place of my lord, just beginning of the second Howrah bridge from second Hooghly bridge from Howrah.
We therefore are of the view.
That is just compensation for the structure on the land of the appellant should be enhanced to rupees 1,25,000. With the aforesaid modification only in impugn award, we confirm the order passed by Learned Area Tribunal, Howrah, as we do not find any infirmity in the same. Therefore, land value has been increased and structure has been increased.
So you show us that in terms of this order, enhancement compensation has not been paid.
Yes, and along with other consequential benefit.
With the aforesaid modification, we confirm the order.
That is the main.
Howrah.
Yes,
so no question of consequential or not consequential. That's a different. You show us that at the enhanced rate, compensation has not been paid.
My lord, they have given কোথায় ওটা আছে? Page 16. They have, huh? Page 16, my lord.
Yes.
Page
1-6.
Huh?
Page
1-6.
Page 16, my lord.
Yes.
16, annexure P3. বার করুন ওটা।
Page?
Annexure 16, page 16, annexure P3. Land value 25,000 টাকা দিয়েছে per কাঠা।
Sir, kindly come to your charge of contempt. Kindly come to the charges.
Yes.
Where have you summarized?
Yes.
Where have you summarized, sir?
Yes.
The charges of contempt.
Yes, I'm coming, my lord.
It's not in the prayer.
1 minute, 1 minute, my lord.
Not in the prayer.
Yes, yes. 1 minute, my lord. Yes, a content application to.
Where are the charges of contempt?
Content. Oh, it's a contempt application. Kindly see 1 minute time, my lord.
Yes, yes. You take your own time, no problem.
My lord, kindly come page 20.
From your petition.
Yes.
Petition.
From my contempt petition.
Page?
Page 20.
Yes.
20.
Yes, sir.
Last that one paragraph, I will take some time. The said appeal had been finally heard by the division bench.
Yes.
Division bench of the Honorable Court, presided by the Honorable Mr. Justice Chitranjan Das and Honorable Mr. Justice Aniruddha Rai, and in this presence, learned advocate appearing on behalf of the applicants and also learned advocate appearing on behalf of the state of West Bengal by a judgment dated 26/2022. The Lordship had been pleased to announce the valuation of the land to rupees 20,000 taka per kata from rupees 9,526 per kata, and compensation on structure under acquisition in respect in present case had been announced to rupees 1,25,000 in place of 43,000, etc., along with other consequential benefits. Along with the consequential benefits and reliefs thereon under Section 18 of the Act 1/1894 to the appellants within a period of 3 months from the date of judgment. 3 months.
You show me that 1,25,000 was not paid.
No, 1,25,000 land value.
That's right.
And 1 lakh for the house. But structure value. Sorry, structure value. And my grievance is that, as per the judgment of the Honorable High Court, the consequential benefit, the main factor of this case, my lord. These are the basic factor, but the consequence is solicium is 30%, interest is 15%.
You show us from the division bench our order that those were directed.
Yes. Division bench order. Exactly.
Page 74.
Benefit. 1 minute, my lord.
Where is the single bench order?
1 minute.
Page,
my lord.
Mr. Sengupta, page. Single bench.
70.
Single bench order.
74.
Single bench.
Single bench? That is 18.
Oh, actually 18. So first, yes. Order 41 procedure.
I will start from page 73, 9, paragraph 9. I will start.
Sir.
Paragraph 9, page 73. Have you got it, my lord?
Sir, content, I will look at the direction, not the observation. Show me the direction. Show us the direction.
Oh,
Show us the direction.
1 minute, my lord. अच्छा मतलब अच्छा they have page 17 my lord
Yes.
page 17 what they have paid page 17 what they have paid
17
17
from the content application.
Contempt application
Note.
written notes of argument
Written notes.
Come to page 16, my lord.
Bolo.
My lord, kindly come to page 16 of their written of our written notes of argument.
16.
Page 16 of our written notes of argument, my lord.
In my brief, there is no 16. It's enclosure 3 up to page 15.
Annexure P3, my lord.
Enclosure 3. Madam, there is no 16. It's only up to this page 15.
Then, my lord.
1 minute.
It is an affidavit in reply, my lord. Sorry, my lord. This is an affidavit in reply, page 16. Aapni pichhone jaan. This is an affidavit in reply, page 16.
Page 16, reply.
Page 16, my lord. My lord, there is a comparative chart of assessed enhanced valuation, my lord, and there are two sets of amount, my lord, which they have already paid to my client, my lord. Which they have already paid to my client, my lord.
Madam,
can I give you this copy, my
court
lord?
will not go into this arithmetical niceties.
Yes, my lord. No, my lord. No, my lord. That is not my senior, my lord. He wants to say that.
You show us it was not paid in terms of
No, my lord.
1,25,000.
My lord, they have already paid the amount. My lord, only the point is, my lord, the interest portion. Interest portion, my lord, they have already paid
What is the direction
interest
for
also.
payment of interest? Show
My
me.
lord, they have already paid the consequential benefits, my lord. They have already paid the interest, my lord.
You show us from our order that interest was directed to be paid
My lord,
separately. Show us.
My lord, the consequential benefits, my lord.
Madam, we cannot travel beyond the order. If it is a wrong order, it's a wrong order. You show us from the order.
My lord, only the consequential benefits.
You show us from the order that all those are directed to be made. Show us consequential payment were directed to be made.
My lord. My lord, page.
Show us.
Page 74, my lord, paragraph 15.
Read
Page
on.
74, paragraph 15. The state is directed to pay the enhanced
The
compensation.
state is directed to pay the enhanced compensation along with
other
consequential
amount pending.
To the appellants within a period of 3 months from date.
Yes, my lord. They have already paid, my lord, the interest. They have already paid the interest, my lord. But they have paid the interest of 9% interest for 1 year, my lord. That is from 30th May 1981 to 29th May
Madam, this
1982.
mathematical deduction, we will not go in the contempt. If you have grievance, I will grant you liberty to challenge that portion, whatever way you want to challenge. But this is not the contempt jurisdiction.
My lord, they are paying the interest on the basis of the earlier amount, my lord, not on the basis of the enhanced amount, my lord.
So this calculation part, the contempt court will not go into it. If you have any grievance, then you have to follow the other methods of challenging that order. You cannot challenge the order in a contempt. You cannot challenge an order in contempt.
My lord, kindly liberty may be granted to move that portion to the appropriate forum, my lord.
Yes.
Well, I believe the order has
no content.
No, there is no content. And that's it. 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 That's it.
Ashok, give it.
The appropriate authority.
Land value কোথায় লেখা আছে এখানে 20,000 করে regarding enhancement tune of 25,000. 25,000.
Judgment form
25,000 payment করেছে তো land value
Appearance
তো
গুলো দেওয়া
25,000
রইলো।
payment
দেয়নি তো 20,000 দিয়েছে
না না judgment.
This is a content proceeding
আসতে বলবেন দেখান এখানে
where you take your seat. Don't unnecessary exhaustion করবেন না. Take your seat.
কোথায় আছে এখানটা
Wherever, if you find anything to submit, then you stand and then you make your submission. This is a content proceeding.
direction নয়
This is a hearing. This is a hearing of a content application on affidavits. Full stop. Paragraph. The content proceeding has arisen from an order dated
সেটাই তো লিখে দিচ্ছে
from a judgment and order dated July 26, 2022. Annexure A5 at page 66 to the content application. Full stop. Paragraph. The parent dispute was with regard to assessment of compensation in a land acquisition proceeding.
page 72
Challenging the quantum of compensation, the land loser petitioner had first travelled the jurisdictional civil court under section 18 of the Land Acquisition Act 1861.
1984 Act 1.
Oh, 1984.
Sorry, 1894.
1894.
Yes.
1894
Bracket A, Act 1. Bracket A for short, the Land Acquisition Act. Full stop. Compensation was adjudicated upon. Paragraph. Being agreed by the said assessed compensation, adjudicated compensation by the jurisdictional district court under section 18 of the Land Acquisition Act. The petitioner preferred the statutory appeal being FA 244 of 2004 before this court. It being agreed by থেকে প্যারাগ্রাফ কিন্তু ঠিক আছে এটা মাথার উপর ফ্যাক্টস এটা ফ্যাক্টস হচ্ছে by the said judgment and order dated July 26, 2022, the appeal has been disposed of and was allowed to the extent that the compensation component was enhanced at a sum of rupees 1,25,000 from the one which was adjudicated upon under section 18 proceeding at a much lower rate, much lesser rate. First up. Paragraph. The petitioner has কি বললাম? কোন জায়গাটা?
My lord, may I disturb you, my lord?
Yes, yes, yes.
Page 72 of the contempt application.
70.
72.
Uh,
And here, my lord, 25,000. Yes, yes.
per
25,000.
kata instead of 6410. I'm writing that. কি বললাম? And was partly allowed to the extent by enhancing the land value from rupees 6410 per kata to rupees 25,000 per kata. And the structure value was assessed, was enhanced.
It's a value report. Report
from rupees 1 lakh to rupees 1,25,000. হলো?
এটা ওদের কথা বলছে। আপনাদের ভালুয়ারি রিপোর্ট মানছে না।
The rest of the order passed by the Section 18 court was not interfered with. The state was, paragraph. The state was also directed to pay the enhanced compensation as mentioned above, along with other consequential amount pending, to the petitioners, being the appellant therein, within a period of 3 months from the date of the said judgment. Full stop. Paragraph. Submissions. Mr. Bhudev Bhattacharya, learned senior advocate, appearing for the petitioner, submits that the state has paid the enhanced structure value as assessed by the division bench, and also the enhanced land value as assessed by the division honorable bench, coordinate bench.
They have paid that 20,000 per kata land value.
কারা দিয়েছে? ওরা দিয়েছে, কিন্তু জজ সাহেব বলতে যে 25,000 টাকা।
হ্যাঁ, instead of 20.
Instead of 20, কি হয়েছে?
Instead of 20,000,
25,000.
They have given 20,000. They have paid
20,000
দেখি
per kata. They have paid.
Show me. From record.
From record. এটা ওদের দেখো। 1 minute.
ডকুমেন্টটা দেখাতে কোথায় ইয়ে হয়েছে?
Affidavit in compliance on their behalf, my lord. They are annexure 1.
Which page? Show me. Show us.
Their affidavit of compliance, my lord. Page 6.
Page 6, affidavit of compliance. Show us that they say it is 20.
7.
Wait.
7.
Page 7, column 11.
Compliance, yes. Show us.
Column 11, my lord.
Show us.
No,
That
column
they paid-
15 we have categorically indicated.
Which page?
Page 7.
Yes, madam.
Land value as per order, follow.
Which page?
Like they are compliant.
Page, which page?
No, compliance report.
Oh, annexure.
Page 7.
Page 6, 7.
Yes. Show us it was paid at the rate of 20,000.
That 11.
Item number 11. Item 11.
Mr. Sengupta, kindly take.
15. Column 15.
No.
Total structure value as per the order of the Honorable Court, 1,25,000.
Land value.
Kindly come to 11. Come to
Land.
11. Serial number 11.
11.
Yes. 20,000
per
per kata.
So directed 25,000.
Yes.
But if you
Yes,
also
yes.
kindly take trouble to see the
Yes.
ordering portion,
Yes.
which we are supposed to carry out, the paragraph 13, 14, and 15. We have
the order.
From the order in, the order in contempt.
There is no.
If your lordship kindly take trouble to see once more. 13, 14, and 15 altogether.
Which order? 15. Land.
Yes. Taking into consideration all these facts, learned elite tribunal.
No. Kindly come to first. Before that, kindly come to 6. Para 6.
Paragraph 6.
The court affirmed the land value of the aforesaid land as decided by learned elite tribunal. Regarding enhancement to the tune of 25,000 per kata instead of 6,000 per kata.
Yes.
Yes. This court affirmed the land value of the aforesaid land as decided by the learned elite tribunal regarding the enhancement of the tune of rupees 25,000 per kata instead of rupees 64,110 per kata as decided by the LA collector Howrah.
Next para.
Next para. Taking into consideration such finding of this court, FA such and such finding to the effect that the applicant land holding such and such, holding number such and such are in the same vicinity, learned tribunal limited the amount of compensation for land to the rupees 25,000 per kata so far as per the land of application is concerned.
Yes, next para.
25,000
That is the
Next para. We have of considered view.
vicinity.
within the vicinity of the 25,000, it's a limit.
Next para.
Next para. We are on the considered view. This court, having decided the value of similarly situated land in respect of the holding number such and such, Howrah, per kata, learned LA tribunal could not have taken a view otherwise. We also, being a coordinate bench, cannot take a different view. We affirm the order of LA tribunal so far as the valuation of the land in respect of the holding number such and such, Howrah is concerned.
25,000 per kata bolo.
So show us that you paid 25,000 per kata.
It appears that we have paid.
Kindly come to column 11.
Yes, that is what I am on, Millard. Page 7.
Can I disturb my lord?
No.
No, let him answer.
The same paragraph, my lord, can you see? last part, 7, paragraph 7 of page, internal page 5, taking into consideration such finding of this court in FA number so and so, and the finding to the effect that the appellant's land that is holding number so and so, and holding number so and so, however, are in the same vicinity.
That 25,000 has been directed.
Yes. Yes.
You, Mr.
Yes.
Sengupta, you show that at the rate 25% you have paid.
Yes.
So far my records are concerned, it appears that we have paid as per the column 11, 20,000 per kata. This is the which is troubling. I have to take instruction to that extent.
Come back on the next day. Come back on the next day. Come back on the next day.
After 2 weeks.
করতে হবে না, করুন। With reference to the entries, both side এর নাম দিয়ে দেবেন, তারপর লিখুন with reference to the entries made in paragraph page 7 of the compliance report filed by the alleged contemner, comma, Mr. Shumon Sengupta, Learned Counsel, appearing for the contemner, submits. He shall take instruction and
clarify the position.
Actually, yes. He shall take instruction and clarify the same on the next date.
2 weeks after. 2 weeks. 2 weeks after.
Full stop. The clarification has to be provided before this court in the light of the direction made in the order dated July 26, 2022, wherefrom this contempt proceeding arose. Paragraph. Pendency of this however,
kindly indicate.
The alleged contemner shall also be at liberty to correct if any erroneous payment has been made, which is not in consonance with the direction of the coordinate bench dated July 26, 2022, and shall come up with the correct figures. Post up. Pendency of this proceeding shall also not preclude the alleged contemner to release the correct payment in favor of the petitioner in the meantime,
if at all,
and file a report before this court on the next date. 6th August.
As your lordship pleases. So I just indicate one thing. So far, if we find ultimately that there is some dues, so in that event, Millard, we have to arrange the fund and we have to disburse the same. In that event, we require some time.
You come up with that statement.
Clarification. Yes.
That statement that yes, fairly, let's say,
if it is at all, yes,
10
I will
rupees due, we shall pay off. I will grant you time. We will grant you time.
Obliged to lordship.
The matter shall appear under the heading কি আছে? Contempt application within bracket assigned on August 6, 2025. হ্যাঁ, 6 তাহলে পুরো লিস্টেই থাকুক। হ্যাঁ, কন্টেন্ট গুলো হয়ে যাক। আমরা যেগুলো ফিক্স করেছি সেগুলো তো আলাদা। হ্যাঁ, অন্য যেদিন যা ফিক্স আছে আছে। একদম আমরা বলতে চাইছি, জজ সাহেব যেটা জিজ্ঞেস করছেন যে অন্য কোনো দিন আমাদের আর ফিক্স আছে ডিভিশন মে, তারপর যদি আবার স্পিল ওভার করে তখন 20 ঠেলে দেবো সেগুলো।
ইউটিউবটা বন্ধ হবে না?
Yes,